And we're good to go, Senator.
Okay, thank you. Welcome. I am Senator Sharon Carson from Senate District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that, 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. Number 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. Number 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. Number 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. Number 6, finally, let's start the meeting by taking roll call attendance. When each member states they're present, please state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator Gannon.
Senator Carson, I'm so sorry to
Yes.
interrupt. There's someone that I don't know in our meeting as a panelist. So I don't know if we want to.
I don't know who that person is.
I don't.
We shouldn't.
Should we recess? Do you want to recess for a minute, or I can just remove him? And if it's someone that wants to testify, they can sign in through the public link.
Yes, I think that's fine.
Okay.
Okay, so we're going to go ahead and take the roll call. Senator Gannon.
Thank you, Senator Carson. Senator Bill Gannon in Sandown, New Hampshire, in my home. 2 of my kids who are attending Timber Lane Public Schools are Zooming in rooms nearby, and I don't think they'll come in.
Okay, thank you. Senator French.
Harold French, Senator District 7, in my home in Canterbury, New Hampshire. There are people in the house, but not in the room with me at this time.
Okay, thank you. Senator Whitley.
Good morning, Madam Chair. I am present here in my house in Hopkinton, and I am alone in my office.
Thank you. Senator Khan.
Good afternoon, Madam Chair. Present in Keene at home, and my wife will arrive back shortly, but won't be joining me.
Thank you. And Senator Carson. This is Senator Carson. I am at my home in Londonderry, and my daughter is in an adjacent room, and I've got a couple feisty dogs. So hopefully you won't hear any barking as we get through the public hearing. Okay, we're going to go ahead and start the public hearings. We're going to open the public hearing on Senate Bill 40 and recognize the prime sponsor, Senator French.
Thank you, Madam Chair. And for the record, once again, I am Harold French, Senator from District 7. I'd like to present to you Senate Bill number 40, which is relative to informed consent to search a motor vehicle. This bill is pretty much just to codify what's already law in the state. And I'll take you through a little bit of it. Section 1 says a law enforcement officer may legally conduct a search of a motor vehicle without a warrant under this chapter if the law enforcement officer expressly informs the operator of the motor vehicle. Now, this is where it's already law. The operator has the right to refuse to consent to a search. B, any refusal to consent to a search shall not constitute a basis either for probable cause to arrest the operator or reasonable suspicion to detain the operator. The operator cannot be charged with any crime or violation for refusing to consent to such search, and the operator cannot be further detained for refusing such a search. I feel oftentimes when people are stopped and asked if they can have their vehicle searched, they do not realize that they have these rights, and they have these rights for very good reason. So the goal of the bill is just to ensure that people are informed of the rights when law enforcement asks to search the vehicles without a warrant. That about sums it up.
Okay, thank you very much for your testimony this morning, this afternoon, Senator. Are there any questions from the committee? Senator Khan?
Thank you, Madam Chair. Senator, thanks for your introduction and bringing forth the bill. I was wondering if this deviates at all from the Law Enforcement Commission's recommendations?
I don't know why it would, but maybe we'll hear from some of them if it does. This is strictly to inform people of their rights, and I don't believe law enforcement would be against that, but we'll wait and see if they're here to testify.
Madam Chair.
Follow up?
Yeah, thank you. I guess, was this a part of the LEAC's recommendations? It was not. Okay, I misunderstood. I thought perhaps it was. Okay, thank you.
Thank you.
Are there any further questions? Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question, Senator French. So you mentioned this sort of just codifying new law. So am I correct that it doesn't create a new right?
Thank you, Senator, for your question. This codifies what is already the law. The only thing this changes is they must be informed of this should a search be requested by the stopping officer.
Great. Thank you for taking my question.
That part has changed. Thank you.
Are there any further questions? I have a question, Senator French, and I'd like to discuss on line 12, letter D, the operator cannot be further detained for refusing to consent to a search. Is that existing law or is that new?
I don't think, I would assume that's existing. I don't see under what law we have on the books today that would allow someone to be detained for refusing to consent to a search, which is their constitutional right to do.
Mm-hmm.
So I don't see how that would change anything except codifying it.
Okay, I'm just a little concerned about this section because if someone is suspected of some sort of criminal activity, say they're transporting drugs in their car, the police stop them and they say, no, you can't search my car. You just have to let them go. You can't detain them even to get a search warrant so they can search the vehicle. And I'm wondering if we can work on that would have some sort of time period where they can hold the person while they get the search warrant.
That could probably be a possibility, Senator. However, I know firsthand, well, secondhand, of constituents of mine who have been stopped, detained for a great period of time, and then finally, without giving in, been released to go and drive away without the officer really, we don't want fishing expeditions either.
Correct.
And
Mhm.
and oftentimes when you are detained for 40 minutes, an hour of your time, 2 hours, you just give up and say, okay, go ahead and search my vehicle. Well, that's not what we want.
Correct. And just, do you think, Senator, it would be appropriate that they would have to have some sort of probable cause to hold you for a small period of time if they suspect something? I mean, I understand what you're trying to get to, but I'm also concerned where they have a reasonable cause to stop someone.
Yeah,
Okay.
I can
So we can
understand
work
your
on that.
concern. Sure.
We'll work
Thank
on
you.
that. Thank you for answering my question, Senator French. Senator Khan?
Thank you, Madam Chair, and thank you, Senator, again for taking a question. One of the observations of a chief locally was an emergency situation. So I think it actually falls into the same category as the Chairperson Carson's question. That are there some circumstances where a search and the judgment of the officer should be given a certain privilege. And for instance, would be if somebody was experiencing a seizure, for instance, unknown the source, but perhaps there is a benefit to searching the vehicle to determine if that was natural or induced by consuming something that might be present in the car to inform medical procedures. That might be another situation. Would you agree, Senator?
I would think that would be a possibility that we could address.
Thank you.
Thank you.
Thank you, Senator Khan. Are there any further questions from the committee? Senator Whitley?
Sorry, just on this issue, just to clarify. So this sort of requirement for informed consent only applies to those situations where there's no probable cause. Isn't that correct? Yeah. Okay.
Right.
Just to clarify. Thanks.
Okay. Okay, are there any further questions from the committee? Okay, thank you. Thank you, Senator French.
Thank you.
Okay, next we're going to call Joseph Lacaze.
Hello, can everyone hear me?
Yes.
All right, thank you, Senator. Good afternoon, everyone. My name is Joseph Lacaze, and I am the Smart Justice Organizer for the American Civil Liberties Union of New Hampshire. I want to thank this committee for allowing me to testify today. I will be testifying today in support of SB 40. What I would want to point out right from the beginning is something that's already been stated, is that this bill does not create a new right. This bill only informs individuals of a pre-existing right that many people aren't aware that they have. I myself was born and raised here in New Hampshire, and I have been pulled over several times by law enforcement. And I could say that for myself and many individuals who have, people of color, who have had negative interactions with law enforcement, it can be terrifying not knowing how that situation is going to end. It can be very stressful, and there's a lot of things that are going on in your mind at the same time, especially when you're being pulled over and you haven't done anything wrong. So I wanted to point that out. And the second thing that I wanted to point out is that as a person of color who lives in this state, many individuals when interacting with law enforcement, there is a power dynamic there. And when in the face of a greater authority, you oftentimes feel that you have to do or comply with every request that's being made of you, including a request to have a vehicle search when there is no probable cause. And I did want to highlight that, because probable cause, if an officer does have probable cause, they are able to act accordingly under the law to expand the scopes of their stops, and that is currently in legislation. This bill would remove that intimidation or fear factor from individuals who feel that they need to just do exactly what they are told in that situation of being pulled over because they have been there for so long. People in the community have stated that being able to be informed of their rights during this situation will help them make better decisions. This will also help them make informed decisions rather than one from a position of intimidation or fear. And it's for these reasons and more that I respectfully urge this committee to pass this bill and vote to pass on SB 40. I'm happy to take any and all questions.
Thank you very much for your testimony. Does the committee have any questions? Okay. I don't think I pronounced your name correctly. Is it?
It's French. It's actually Lescas, so it would be spelled LA space Scas, but yes, it's Lescas.
Okay. Thank you.
Yes.
As we inform people of their rights, the Miranda rights, there's usually something that they have people sign that they have been informed of their rights. Do you think that something like this should happen as well? That someone who is stopped, they're read their rights here, that they can refuse. Should they sign something that basically codifies that they have refused?
I personally do not see how that would be a bad thing. I think that anything that shows a record of an individual what they were thinking at the time of their interaction with law enforcement would be beneficial. Having to sign a form that says that they are not giving consent to have their vehicle searched, I think that does help. But again, I can't speak for every community member when it comes to that, but the ones that I have stated that being able to be informed about it, that is the key, that they know that they have this right that they didn't even know existed.
Okay. Because the way that I'm thinking about this is that someone will get stopped, they will be read this right about the right to search the vehicle, they have the right to refuse. But what happens if they say, okay, you can go ahead and search my vehicle, and the police should or could find something? And what I'm concerned about is them going back and saying, well, I was never read my right. And then all of a sudden the case gets thrown out of court because it's been a violation of the law. So that's why I'm thinking, should there be something that somebody signs that they, I consent, I do not consent. That way there's a record for both the person driving the vehicle and the police officer that could be part of whatever paperwork that they have to take care of.
I believe Senator French has something to add on that, but I can wait till after he speaks to respond.
Okay, Senator French, do you want to chime in?
Yeah, Senator, that's in section 3.
Okay.
I failed to bring that to your attention.
Okay. I'm just wondering if they're going to have to create a document, if we have to give them 541A, to go to JELCAR to create the document, unless you want it in statute.
By the way, probably.
Okay. All right. So just let me make a note here. Okay. All right. Thank you. Does anyone have any further questions? Okay. Seeing none. Thank you very much for your testimony this afternoon.
Madam Chair, it's Deb.
Yes.
We have two attendees with their hands up, and I don't know if they just have questions, or I didn't know if you wanted to speak with them.
Well, I have two other people who have signed up. Why don't we go through those two folks and then we'll add them at the end?
Fine.
Okay, next we'll call Albert Scher.
I don't see Albert on our list here.
Okay, because I have him down as supporting and testifying.
He's under Buzz, Margaret.
Okay. Buzz, you said? Okay.
Okay, there we go.
You are able to speak.
Thank you, Madam Chair. I apologize for the name confusion. Banks and judges call me Albert. Everybody else calls me Buzz. The committee can do as it wishes. My name is Albert Buzz Scher. I'm a professor of law at UNH Law. I've been there for 27 years. I practiced I was a public defender in New Hampshire for 13 years before that. So I've been opening actually the Keene Public Defender's Office back in 1982. So I've been involved in the criminal justice system in New Hampshire for about 40 years. At the law school, I teach the core foundational course in criminal procedure, which is the intersection of the Constitution with police investigation, fondly known to some as cops, robbers, and the Constitution. So this is squarely in my area of expertise. As a note, I'm testifying in my individual capacity only. The opinions I express are my own, and not those of either the law school or UNH itself. So I worked with Senator French to some degree in development of this bill. I think much of the conversation has already captured some of what I was going to say, and I've filed written testimony. I mean, it's really a common sense bill that basically informs people of a right that they have under the Constitution, but the huge majority of people don't know about. And that's particularly important in a stressful situation when they're on the side of the road. You know, really what happens is, to pick up on something that Senator Carson said, when somebody is stopped, and when this happens, is somebody is stopped for a reason other than to search their car. They're stopped for just speeding, maybe they're stopped for a taillight out or a registration or something. And at some point in the process, the officer takes a shot basically and says, hey, will you consent to have the car searched? And it's at that point where they've already been stopped for something else, and the officer wants to search the car. At that point, if the officer has probable cause to believe there's contraband or something illegal in the car, one, they have probable cause to get a search warrant, but two, they also have probable cause to arrest the person. So they can detain the person while they get a search warrant, and that will take care of, I think, some of the concerns that were expressed. If you have probable cause to get a search warrant for something illegal in the car, let's assume it's drugs, which is the huge majority of the time what we're talking about, then you have probable cause to arrest the driver who's in possession of the car. And so, though perhaps the language of Section D that was referred to, I think, by several senators, can be improved, I think that is the state of the law in this area. And also, it's the case, if there's an emergency, then an officer will have probable cause to try and help resolve the emergency under the exigent circumstances doctrine and or the community caretaking doctrine. Both of those doctrines would allow, in the circumstance of an emergency, a police officer to get into the car for the limited purpose of finding a, perhaps medication or whatever it is to help deal with the emergency if it's a seizure. I would point out, as I lay out in my statement, I would point out that there are other states that do this. There's 5 states who have their Supreme Courts have found that they must be informed of their right to refuse the consent. And a 6th state, Colorado, has a statute that captures some version of that. The 5 states are an unusual mix of states: Arkansas, Mississippi, Washington State, New Jersey, and Hawaii. There's also a number of municipalities across the country who have provisions like this, either policy of the police department or by decision of the municipality. You know, Durham, Fayetteville, Greensboro, North Carolina, New Orleans, West Memphis, and Chattanooga, Tennessee, and interestingly, Wentworth, New Hampshire. Wentworth, New Hampshire has a consent to search form, which virtually every police department has, that contains in it the language, you have and an individual signs the consent to search form when they consent to search. It informs them that they have a constitutional right to refuse to consent. So, and also there's as I referred to in my statement, my written statement, there's a New Hampshire Supreme Court case that makes it clear that back in 2006, the Bureau of Highway Patrol Enforcement, which is the group that often that is stopping trucks for commercial violations, there's a case where the officer from the Bureau was informing the person who was stopped of their right to refuse. So I think, and I would. One more thing, I would point out to the court, excuse me, that's my go-to language. I would point out to the committee that the Attorney General's law enforcement manual effectively recommends, and that language is in my statement, effectively recommends, says that this is a good idea. As one of, I think, Senator Carson, you raised, it protects police officers from accusations later on that they were forced to consent. It wasn't a voluntary consent. And simply having each police department in New Hampshire has a consent to search form, and the language varies from form to form. This is simply a matter of rewriting that form and including the language in paragraph 1 of this, of the SB 40. It's a pretty straightforward proposition. That said, if the committee has any questions, I'm more than willing to answer them.
Thank you very much, Attorney Scher. Is there anyone any of the committee members who have a question? Senator Khan. Senator Khan, you have to unmute.
Yeah,
there we go.
I got that. Sorry for the background phone. I heard you talk about community caretaking and probable cause doctrines would take precedent. Is that a suggestion back to the committee that including those, at least through reference in this, would be of value?
You know, I tend to be, in thinking about statutes, I tend to be a minimalist. You know, I think the more you put in there, the more confusing it gets. You know, the community caretaking doctrine allows the police, when they sense that there's an emergency unfolding, allows the police to act way more expeditiously than they normally would under standard Fourth Amendment or Part 1, Article 19 of the New Hampshire Constitution doctrine. So that's existing whether it's written in there or not, number one. Number two, the exigent circumstances doctrine does a version of the same thing, and many people see the community caretaking exception as a part of that doctrine. And it basically says if there's probable cause to believe, you know, there is some sort of emergency going on that will require immediate action, I'm grossly simplifying it, of course, then that allows the police to act. So while, let me just take a look at the language of D. 1D says the operator cannot be further detained for refusing to consent to a search. That really is, there's no law that says you can be arrested for refusing to consent to a search. That's all that is intended to capture. I'm not opposed to, if it be useful, to helping the committee come up with language that would more explicitly refer to exigent circumstances doctrine and the community caretaking doctrine. So, as always, a long-winded law professor answer.
Thank you.
Are there any further questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for your testimony. So I'm curious about whether you mentioned that there is some guidance already within the Attorney General's office on this issue. So would you agree that it wouldn't be particularly burdensome to add this informed consent requirement?
No, it wouldn't be burdensome at all. I mean, I really think it's just a matter of changing forms. Either the state creates a form to be used by every police department, or each police department do it. But the form would essentially have on it paragraph 1. Where they would in 1A through D, it would simply say, here are the rights you have. Here's what it's important for you to know before you, as you decide whether to consent or not. It's not a complicated proposition at all.
Thanks for my question.
Are there any further questions? Attorney Scher, you mentioned a Supreme Court decision. Would you be willing to share that decision with the committee?
Yes. Let me be clear. The Supreme Court decision of which I spoke is one in 2006 that it doesn't deal with this issue directly, but in their description of what happened in the case, it states that the officer from the Bureau of Highway Patrol Enforcement informed the individual that he had a right to refuse to consent to search. The individual later consented to search. That's what that is about. But I will certainly share that with the committee.
Thank you very much. Are there any further questions from the committee? Okay, seeing none. Thank you very much, Attorney Scher.
You're welcome.
Okay, next we're going to hear from Melissa Davis.
Thank you, Madam Chair. My name is Melissa Davis, and I'm here to testify on behalf of the Board of Directors for the New Hampshire Association of Criminal Defense Lawyers in support of SB 40. I have practiced criminal law in New Hampshire for over 15 years, first as a public defender, and now as the director of the Criminal Practice Clinic at UNH Franklin Pierce School of Law. That means I still continue to represent clients as part of my work with the clinic. I do make this statement in my individual capacity as board member for NHA-CDL. In my individual capacity and as board member for NHA-CDL, the opinions I'm expressing are solely mine and are not those of either UNH Franklin Pierce School of Law or the University of New Hampshire. I'm in support of SB 40 as it allows individuals the time and information necessary to make the important decision of whether or not to waive their constitutional right to require a warrant for searches of their cars after being stopped by police. As described to me many times over my career by individuals who've been stopped by police and asked for consent to search their vehicle, here is the general situation this bill aims to address. A person is pulled over by a police officer for a motor vehicle offense, usually something like speeding or failure to use a turn signal or a light out. The officer approaches the vehicle and asks maybe 1 or 2 questions relevant to the reason why he stopped the vehicle. Questions such as, do you know why I pulled you over? And can I have your license and registration? However, questioning by the police officer soon turns to other topics irrelevant to the reason why the vehicle was stopped. Where are you coming from? Where are you headed? What have you been doing this evening? It's at this point where a driver who is already feeling the normal human reactions of fear and nervousness at being pulled over by a police officer begins to feel as though this officer may believe that they have done something wrong, something more than not using their turn signal or speeding. And it's at this moment that the driver begins to feel like they have to do everything the officer asks them, or they will be subject to further investigation, further detention, possibly arrest. This feeling has been described to me by clients who have done nothing wrong, by friends, even by other attorneys, and I have felt it myself. But my feelings in that moment do not compare to those of people of color who are stopped at disproportionately higher rates in this state, and for whom a police encounter brings an entirely new level of fear and anxiety. For these individuals, appearing cooperative and compliant by consenting to waive constitutional rights may seem necessary and not a choice. Over and over, I have been told, and even witnessed through recorded body cameras provided through Discovery, how people who initially try to assert their constitutional right to a warrant for a search of their vehicle are repeatedly interrogated by police in their efforts to obtain verbal consent to search. They are often not informed of their right to refuse. And even when they are not told that their refusal will not be held against them in some way or somehow used to charge or arrest them. This bill, as has been stated previously, does not change the current law. It does not give anyone more constitutional protections than they already have. This bill requires police to tell people what the law is, and that if they choose to exercise their constitutional rights, it cannot be used against them. This should sound familiar. The Constitution already requires individuals to be informed of their right to remain silent, their right to an attorney, and their right not to have those choices used against them. And I can tell you that in my experience, the majority of people sign the form waiving those rights after being advised of their rights and told that exercising them will not be used against them. They still choose to do so. It is a knowing decision rather than one coerced by the very nature of the relationship between investigating officer and individual. The decision that drivers are forced to make right now is somewhat coercive by its very nature. It occurs on the side of the road between individual and police officer after a routine traffic stop has turned into a lengthier detention because a police officer has asked to search someone's constitutionally protected private space for whatever contraband this officer may think he will find. This bill helps to change the nature of that encounter into one where the individual can make an informed choice. Should they refuse to grant consent, the officer is free to seize the vehicle and seek a warrant should he believe he has sufficient evidence to do so. Should this individual sign the form and agree, then absent the presence of other coercive tactics, any incriminating evidence can be used against them without argument that their consent was forced. This bill protects both individuals and society's interest in fair prosecution, and as such, I offer my support.
Thank you very much for your testimony, Ms. Davis. Are there any questions from the committee? Seeing none. Oh, Senator Gannon has a question.
As far as informed consent, ma'am, without a video, how are you ever going to know if the signature was, you're saying that there's an inherent feeling of coercion at the scene. You're still going to be just as apt to be coerced to sign as to give or verbal consent.
I do think that's where the language saying that, refusing to consent will not be, sort of held against you is important in that form, just as it is in the Miranda form. And so when someone signs that form, it becomes part of the police record in the investigation in the case and is a record of their willingness at that point. Obviously, greater circumstances are covered by body cameras, but we have for a long time relied upon simply a signature on a Miranda form.
Okay, thank you.
Are there any further questions? Okay, seeing none. Again, thank you very much, Ms. Davis.
Thank you.
Ms. Martone, you said that there were a couple of people who wanted to speak. Are they still here?
Yes, Madam Chair. Well, I don't know whether they want to speak or if they have a question, but there are 3 hands up. The first one is Leah Cushman.
Okay, and can you tell me who the other 2 are?
Yes. This one is Asma El-Houni. And the third one is Joseph Eber.
Okay, okay. The second one, and I didn't get the name.
It's spelled
As-
ASMA, first name, last name ELHUNI.
Could you please repeat that?
ELHUNI. Elhuni?
Okay, I might need some help with that, but, okay, why don't we hear from Ms. Cushman?
Go ahead, Margaret.
Thank you, Madam Chair. My name is Leah Cushman. I am a state representative for Ware and Deering, Hillsborough County District 2. I'm also a registered nurse and a mother. I'm speaking today in favor of SB 40. I thank you for the testimonies and the good conversation and questions here. I'm coming from a medical background and I'm a staunch advocate of informed consent, and I believe that this carries over into our rights in encounters with police officers. And I just want to say that, you know, in medicine and in healthcare, we make sure our patients have full informed consent of what their rights are so that we can be sure that they are respected. And this applies to interactions with police officers. So I ask that you would please support this bill. Thank you.
Thank you for your testimony, Ms. Cushman. Are there any questions for Ms. Cushman? Okay. Jenny?
All right, Senator, I just wanted to mention if Ms. Cushman and Mr. Ebert and Ms. Aluni, I'll make sure that they sign up on the website as well, just so that we have a record of them in our system for testifying today.
Okay, thank you, Jenny, for making that announcement. Okay, next is Asma El. I didn't get the rest of it, so Alhuni. There we go. Good afternoon, Ms. Alhuni.
Thank you, Senator Carson. Yeah, so my name is Asma Alhuni, and I do believe I signed up on the website. So I don't know, I'm not too sure why it didn't go through, but so yeah, I'm the Movement Politics Director for Rights and Democracy, and I'm speaking on behalf of the organization, but also in my own individual capacity as well. I am speaking in favor of this bill. It's imperative as lawmakers to pass like common sense bills, and the average person in New Hampshire unfortunately does not know all their rights, especially when it comes to policing. This nation battles against unchecked police power, and it's vital as lawmakers we're sending the public a clear message that abuse of any kind will not be tolerated, and to ensure that what you mean, what you say, we have to protect people from unchecked power. So police should absolutely tell people about their rights, because as statistics keep showing over and over again, all across the nation, police are searching vehicles, especially vehicles from people of color, at a much higher rate than others. And people have a right to push back against this, right? This happened to my son, who is a Black man. I was stopped for turning right on a red light, and the police officer said there was no, that it wasn't allowed. But as the previous speaker spoke, I was asked, where am I going? Why am I out so late at night? So these questions are like very, you know, it's scary for people. And I was genuinely scared. So yeah, so people who did nothing wrong are, you know, they're going to be afraid. They're going to think they have to follow whatever that police are asking them to do, even if they have a right not to be searched. So again, as said earlier, this protects everyone, and it's important that people know what their rights are. This isn't a new law, but it's just ensuring that the rights people have are respected. And that's all this is, just a common sense bill. So hopefully you support this. Thanks so much.
Thank you for your testimony, Ms. Alhuni. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for your testimony. Yeah. You know, we all know we are in a historic time of a nationwide reckoning on racial justice, and, you know, working towards dismantling our systems that we know have also been shown to impact people of color. And so I'm wondering if you see this bill as part of a larger effort to dismantle systemic racism.
Thank you, Senator Whitley. Absolutely. This is a step in the right direction. Absolutely. And I also just wanted to mention, one reluctance I do have is the part on signing a document. I just kind of hope we think through this just a little bit more, because there are, for example, immigrants who don't speak English, and oftentimes we tell them not to sign something for their protection. And so just making sure that we are also ensuring that police, for example, if somebody doesn't speak English, that they're following the laws by ensuring that there's an interpreter or whatever, and they're not, yeah, just that little aspect of it. But yes, absolutely, this bill is definitely in terms of respecting Black Lives Matter's demands and the demand for equity in our country, so that we're not continuously targeting people of color, and we're moving towards a more just and transformative society that is beneficial to all of us.
Thank you for answering my question, and that point about making sure that whatever needs to be signed should be accessible to everyone.
Yeah, thank you.
Okay, are there any further questions? Okay, seeing none, thank you for your testimony. Before we go any further, Jenny, I got a text message that there are people who wish to speak who signed up and they're not on the list. I don't know what happened here, but maybe we can just ask them to raise their hands like the others have done. If we can go ahead and do that. The next person we have to speak is Joseph Eber.
Hi, good afternoon, everyone. My name is Joe Ebert, E-B-E-R-T, and I'm captain with the State Police. I oversee our Investigative Services Bureau, which is the Detective Bureau of the State Police. I did sign up online. I'm happy to go back through that process, though, if it for some reason didn't come through. The State Police is taking no position on this particular bill. However, I think there is a good chance that we could get to a position of support. The concerns brought up, I think a lot of the topic of discussion has been subsection D. And I'm in agreement certainly with Senator Carson that this is something that we would like to see spelled out a little bit better. The operator, where it says the operator may not be, the operator has the right to refuse to consent to a search. And then if you look at D, the operator cannot be further detained for refusing to consent to search. Not for just the refusal of the consent to search, clearly they cannot be detained. However, if you are seeking a search warrant, especially if that search warrant is for the person, something that might be on that person, there would be the necessity to detain that person. I also want to talk about, so it's subsection 2 under that D, where it talks about the operator of the motor vehicle refuses to consent to a search, the law enforcement officer shall cease any further questioning concerning consent to search. I understand, or at least I think I understand where Senator French was going with that line. But I do think that it closes down an avenue of further discussion that the driver may have. So oftentimes it was, and it's been several years since I was on the road. However, when I was having those encounters on the road and I was asking somebody for consent to search, oftentimes somebody, I would advise them of the rights they had via our consent to search form. And I would ask for consent. And if that individual said, no, I don't, I choose not to consent. Okay, that's okay. And I would inform them at that time, I'm going to seize your vehicle at this time and apply for a search warrant. Oftentimes I would have a discussion at that point where the individual would say, okay, well, I don't want that. I would rather just give you consent to search the vehicle. And I would go at length into talking to them about I'm not trying to force you to do that. That's not the purpose of the seizure of the vehicle. But oftentimes that individual had their own motivations for wanting to consent to the search. Sometimes that motivation was they knew that whatever I was going to be seeking a search warrant for within the vehicle was going to be found regardless if the search warrant was granted. So they made that decision at that time to provide consent. So the reason I bring up that scenario is it seems to restrict the ability for that conversation to take place. And again, I don't think that that's something that's a slight for law enforcement. If you're advising the person that you're going to seize the vehicle and apply for a search warrant, you've already made that decision. What I do think is it may be taking away the ability to have that conversation for the driver. So I actually think it restricts the options that the driver has by saying, by utilizing the word shall. So those were the two issues that we saw. I'm happy to answer any questions should anyone have them.
And thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator Whitley?
I'm just looking at that. Thank you, Madam Chair, for taking my question, and Captain Ebert. So I'm just wanting to explore your testimony about sort of, shutting down conversation.
Mm-hmm.
And the way that I read it, it says the law enforcement officer shall cease any further questioning concerning consent. So it doesn't shut down, for example, if the individual in the car had a question and wanted to ask that of the officer, or if there was additional information that the officer wanted to provide. Isn't that correct?
Yeah, so I guess what I would say to that is there was a previous speaker who said they're minimalist when it comes to statutes, and I guess I'm in agreement with that. In that I would, it's very hard to engage in a conversation knowing that at no point you can ask a question. So I do understand what you're saying. It still allows the driver to converse with you, but it becomes a very one-sided conversation if you're not able to ask any question in return. So if that's a protection that is being sought here, and it's the desire of the committee to keep in, we're not staunchly going to oppose that. I just think it does make a conversation very difficult if you can't ask a question.
Are there any further questions for Mr. Ebert? Okay, seeing none, thank you very much for your testimony. Jenny?
So, Senator, just because we have so many people here, I just want to make sure everyone is aware of the policies. What happens for sign-up sheets, and I did check Captain Ebert and Ms. Alhouni are signed up. The problem is that they signed up after 12:30. Senator Carson receives a printout of the sign-in sheet as it stands at 12:30 p.m. We have a very small staff here. We have to have a cutoff at some point so that I can get into committee and we can run it. So just for everyone in attendance, if you're able to sign up before 12:30, before committee starts for all the bills we're hearing today, that will make it much easier. We'll make sure we have your names on the list and you'll be all set to go. The sign-in sheet opens immediately after the bill is scheduled. So you have at the very latest from Thursday until Tuesday to sign up, even over the weekend. So just want to make sure that that is clear to everybody about how our signups are working and what the problem has been today.
Okay, thank you, Jenny. Do we have other people who would like to? Okay, can you tell me how many?
It looks about 5 right now.
Okay. Okay, is there I don't know if there's a way to speak to those. Oh, well, they're listening. So what I'd like to do with these 5 individuals is we have had a lot of testimony on this bill this afternoon. So I'm going to ask you to please not repeat things that others have testified to. And I think what I'm going to end up doing is putting a time limit and of 3 minutes for each person to offer their testimony. Okay, so who is the first person?
We have Mark Bowden.
Okay, all right. Why don't we have them in? Good afternoon, Mr. Bowden.
Good afternoon, Madam Chairperson, and good afternoon to the members of the committee. My name is Mark Bowden. I'm a retired detective sergeant from the New Hampshire State Police. I'm here representing the New Hampshire Troopers Association in this matter. The Troopers Association takes a neutral position on this. We understand what Senator French is looking to do is to codify what's already in practice. As you heard from Captain Ebert, we do have a consent to search form that we use when we do ask an individual to search their vehicle. There's only 2 questions I had on this. One of them that has to relate to section 1, subsection C. where the operator cannot be charged with any crime or violation for refusing to consent to a search. Now, I read that to mean that I can't charge them with anything for refusing. However, you can still charge the person for the underlying offense for why you stopped them or whatever other crimes that are going on at the time. And then the second one is D. The operator cannot be further detained for refusing to consent to a search. Again, I think that there was some testimony you heard from Captain Ebert with some concerns there as well. As he mentioned, if we do stop a vehicle, we do make contact with the driver. If we develop probable cause that we believe there's contraband or something illegal in the vehicle, we'll ask the person to consent to search the vehicle. If they refuse, then we'll apply for a search warrant. A lot of times when we apply for a search warrant, what we do is we seize the vehicle, but we immediately let the person go if they want to leave, unless it's something that we're concerned about that's on their person, but that's a different issue than a consent to search a motor vehicle. So I think that those are the only two issues or concerns that we wanted to bring to your attention. Other than that, we take no position on this because it's already the same way we're operating now. So thank you for your time.
Thank you for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much. Who's next?
We have Penny Dean.
Okay, thank you. Why don't we go ahead? Good afternoon, Ms. Dean. You can go ahead and get started.
Good afternoon, Senator and members of the committee. I'm not going to take up the limited 3 minutes that I have going through all of my objections about this process, but the fact that those of us later are given limited time and those earlier were not restricted, I greatly object to that in other parts of the process. And I think those of you should listen very carefully to what the captain said, because in between his words is the problems and why we need this bill. And by the way, I support the bill. The captain says, well, we just want to ask questions of them. That's called interrogation, and you can label it differently, but it's still interrogation. Secondly, we don't teach social studies and basic civil rights in our schools anymore. I know we don't, by talking to many, many clients over the years. And particularly those who might not have been born in the United States don't understand these rights. And so I think it's crucial that people be given these rights. And when the captain said, well, this closes down an avenue for further discussion, that's risible. It goes back to the fact that they want to find a way to continue to question people beside the road, because even those that are given Miranda waivers, and as one attorney said, a lot of them sign it because the police don't just give them the Miranda waiver information. They give them all this other information. Hey, if you sign this, we got to get you an attorney. We can't help you. We can't talk to you if you do this. So yeah, they give them a Miranda waiver, but they give them all of this other scare tactics. And what happens is it totally scares people into signing it. So this will give a few people an opportunity to save themselves and to not be further harassed. But the bottom line is that you're still going to have, unless one senator said, unless you have police body cameras there the entire time, you're still going to have a great majority of police that are going to still say, yeah, you know what? We can't search your vehicle without doing this, but then we're going to do this, this, and this. And that's what happens all the time. And anyone who listens to police dispatch logs or interrogations or anything that is recorded, they're going to see these are standard police tactics. And those who are not educated in the field may see what the captain said is reasonable. But those of us that are educated in the field, we're laughing with a black sense of humor, going, that is what happens to our poor clients and poor people that simply don't know any better, that they simply believe that if they just let them search their vehicle, they just want to look through it and they're going to let them go. That's 99% of the time a story. They're not going to let them go. And what it's going to do is greatly decrease a defense attorney's chances to adequately defend someone at trial. So this will just give the public, the poor, and the uneducated a better opportunity to have a chance at a fair trial. I apologize, Senator.
No, that's okay. We've gotten to the 3-minute mark. So thank you very much for your testimony, Ms. Dean. Are there any questions from the committee? Okay, seeing none. Thank you, Ms. Dean. Who do we have next?
So the last hand up that I see is David Goldstein.
Okay, why don't we put him through? Good afternoon, Chief. How are you? We have 3 minutes.
Not a problem, Senator. Good afternoon, everybody. For the record, my name is David Goldstein. I'm the Chief of Police here in Franklin. I've been a police officer for 41 years. 23 of those years, I was with the New Hampshire State Police and retired as a uniformed captain. And for 15 of those years, I've been a police chief, serving, and then the remaining years serving as a municipal police officer. I will take just a moment because everybody's pretty much said everything that we agree with. I am representing the New Hampshire Association of Chiefs of Police this afternoon. We don't necessarily take an oppositional position to this, just as you've seen perhaps some language changes and some work on the bill itself. I would only add one very specific thing under the statement D, I believe it is, it says the operator cannot be further detained for refusing to consent to search. We would just add the word after detained, we would add the word solely detained, detained solely, excuse me, for refusing to consent to search. The other issue I would just bring up very briefly is that, yes, we have been functioning under these rules for literally decades now that I'm familiar with. And I don't know a police department that does not have a consent form that they use. And at the same time, if we make a mistake, if we do something that is considered incorrect or appealable, there is always the court system. And I invite anybody to do a quick online search. While I was waiting to speak, I did a quick search and I found 30 decisions alone that address these issues. So this is nothing new to the court system as well. Certainly happy to answer any questions that the committee might have.
Thank you very much for your testimony this afternoon, Chief. Are there any questions from the committee? Senator Khan? Senator Khan, you need to unmute.
Thank you, Madam Chair. Thank you, Chief, for taking this question. I just want to make sure that it seems like you made 2 suggestions to strengthen the bill from your perspective. And the second one here was relative to a form. So back to the chairwoman's question, that they're stating that we need a form would be something that would need to go through GELCAR to standardize that. Is that is that the suggestion you're making?
I would certainly be amenable to that, Senator. As I say, and as you've heard earlier, the Attorney General in their law enforcement manual over the years have made these suggestions, and we've pretty much taken those and put them on paper so that it pretty well outlines the fact that an individual has the right not to have or not to consent to a search of their vehicle. But certainly if there was a particular form, a unified form, I'm sure that we'd accept that as well.
Thank you.
I have to turn this off. Okay. Okay, hold on. I'm trying to turn the timer on. Okay, are there any further questions for Chief Goldstein? Seeing none, thank you very much.
Thank you.
Okay, I'm going to go ahead and close the public hearing on Senate Bill 40.
Senator, we actually still have one hand up, and I believe that
One hand up?
Yeah, Mr. Axelman did sign up after the 12:30 mark.
Okay, Mr. Axelman? Okay, why don't we go ahead and hear from Mr. Axelman?
Mr. Axelman, you should be able to speak.
Mr. Axelman? He's muted. I don't know if he knows that he's muted.
I've asked him a couple times to unmute, so I'm not sure.
Okay. Why don't I just say that we're not going to be execing this bill today, so that if there are individuals that would like to send us their testimony, we'll be more than happy to read their testimony. So why don't we go ahead and we will end the public hearing on Senate Bill 40. Okay. Next, we're going to go ahead and open the public hearing on Senate Bill 41. Right from the beginning, I am going to announce that we are behind, and there are a number of people who have signed up to speak, and I don't know if there are other people that are who would like to speak as well that just did not sign up in enough time. So we're just going to go ahead and impose the 3-minute rule on everyone who's going to be testifying on this bill today. Okay, we're going to open the public hearing on Senate Bill 41 and recognize the prime sponsor, Senator French.
Thank you, Madam Chair. Once again, Harold French, Senator District 7, right here in Canterbury, New Hampshire, covering and just heard from my old police chief in Franklin, so it was very good to hear his voice. I'd like to introduce to you Senate Bill 41. This bill is relative to police disciplinary hearings. This bill would make police decertification hearings open to the public, while providing that portions of a hearing can be made confidential if it's warranted. This is the same setup as for court proceedings. The default is public access with the option of closing a portion of a proceeding on a case-by-case basis. Giving police special treatment by preventing transparency sends a bad message and undermines public trust. Police have enormous power over the public, and that power calls for increased transparency, not less, particularly around police misconduct. I believe this bill is going to be well received by all those it affects. It's going to bring light to areas that in the past have been a little dark. Thank you, Madam Chair.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator French, I have a question, and it begins on line 8 and 9. And it says that the disclosure creates a compelling interest outweighing the public right of access. Can you tell me who or what entity determines that what is a compelling interest?
I believe hold on with me.
Nope, that's okay.
I'm not sure.
Okay. Okay.
How it would be defined, to tell you the truth.
Pardon?
I don't know how it would be defined.
Okay. All right. Are there any further questions from the committee? Okay. Seeing none. Thank you very much, Senator.
Thank you, Madam Chair.
Okay, now I'm going to butcher his name again. The chair is going to call Mr. Lacose.
Thank you, Senator. Very close.
I'll get it right someday.
You're going to get it right by the end of this session. I have faith.
That's fine.
All right. Good afternoon. Again, my name is Joseph Lascaz. I am the Smart Justice Organizer for the American Civil Liberty Union of New Hampshire. Today, I will be testifying on Senate Bill 41. I will be testifying in support of this bill, and I strongly urge this committee to pass this legislation. Over the summer, our state has made great strides at improving transparency and accountability, and SB 41 is aimed at continuing that progress. As things are right now in New Hampshire, police decertification hearings are held in secret. And this is in stark contrast to judges, lawyers, and even state employees such as nurses who have equivalent hearings. as I stated before, I was born and raised in New Hampshire, Manchester, in particular, and I could say that as a resident of Manchester and as a Black man, when I see that situations such as Aaron Brown, who was scheduled to have a decertification hearing held in secret, it is appalling is the word that comes to mind. Aaron Brown is the former Manchester police officer who referred to Black community members as useless, the N-word, and even went as far as to say that he got a new 40 cal to take us out. That refers to me and my family as we live in this state in Manchester, and to hear that a decertification hearing for that level of misconduct was going to be held in secret, that the misconduct could happen publicly, yet when it comes to the accountability and transparency of the resolution of that, it was going to be held in secret. That sends a very, very bad message to community members, especially the community members of color, who have been waiting to have our voices heard, to have our experiences, our negative experiences with law enforcement heard, and to have that accountability measure seen. To put it simply, you can't have accountability without transparency. And as Senator French had stated, this bill would still allow for portions of the hearing to be closed. It's not just a blanket across the board, but what this does do is it pulls back that veil of secrecy that has existed so long in our state regarding misconduct, decertification, and law enforcement. And with that, I would strongly urge the committee to pass this bill, and I am happy to take any and all questions regarding this piece of legislation.
Thank you very much for your testimony, Mr. Lascaz.
Yes, perfect.
You know what it is? I keep missing the S in there.
Okay.
Okay, so again, thank you. Are there any questions from the committee? Senator Khan. Senator Khan, there you go.
Thank you, Madam Chair. And Mr. Lacaze, I think I'd like you to address the questions that the chair had on line 8 and 9. Who would be that person to make the decision? Would it help to specify the hearing officer?
Sorry, I didn't realize I had muted myself back. Okay, so I'm just reviewing the bill text right now just to make sure. So you said line 8, 1, 2. So I am trying to see what was the language that you were speaking about. I just wanted to make sure I'm on the same page.
I think the chair asked the question earlier about who is it that would make the determination about closing a portion of the hearing. It seems like the fix might be to add the hearing officer, but I thought maybe with your experience you might have a position on it. And if you don't, that's fine. But I do think that the chair has raised a good question about clarification. I hope somebody in that long list of testimony, Madam Chair, will address that question.
Sure. So now that I understand exactly what you're being asked, so to my knowledge and from all the conversations that I've had with the appropriate body, it would be Police Standards and Training Council that makes that decision whether or not the hearing would be public or closed. So when the officer would make a request, they would make a request of Police Standards and Training Council to have their hearing private, and then they would have to provide reasons why that hearing would be public, which should be private. But I would be more than happy to work with the committee on clarifying that language.
Okay. Thank you. Are there any further questions? Senator Whitley?
Thank you, Madam Chair, and thank you for your testimony. Similar to my question to the woman from Rights and Democracy, I'm just curious how you see this bill fitting into the overall sort of reckoning we are having with racial justice in our state? I'd be interested in your in your answer to that question.
Well, I see this bill doing two things. One is it's allowing closure for individuals who have experienced misconduct at the hands of law enforcement, especially when it's racially motivated. Again, what I bring up the Aaron Brown situation because this is recent. This is New Hampshire specific. This is not happening in Minnesota. This is not happening in Chicago. This was right here in our state. And the implications of that hearing being held in secret sends a terrible message to our community members who were publicly shamed and referred to in a derogatory manner. I believe the second part about this is it restores faith for the public. So for anyone who has been involved in police misconduct, who has experienced police misconduct, what this does is it shows that accountability measure so that you see the process as to what's happening. There was a situation involving a Salem police officer, Mr. Verace, who he goes on a high-speed chase. I don't know if everyone in this committee is familiar with the case, but goes on a high-speed chase, puts people's lives in danger, even is said to put the public at risk, and gets charged with a felony charge for evading police and reckless conduct. And at the hearing, he was not temporarily decertified while pending a felony charge. Now, Mr. Verace chose to have his decertification hearing public in a rare instance, but the public does not know what is happening behind those closed doors. We cannot have that accountability without transparency, and we can't have faith in the government if we don't know what is happening when it involves community members. And I do believe that this bill is aimed at bridging those gaps and rebuilding that faith and trust.
Okay, thank you. Are there any further questions for Mr. Lescaz? Mr. Lescaz, in referring back to that section, I think when we're talking about who gets to determine what is a compelling interest, do you think that it should be a neutral party rather than the Police Standards and Training Council who are going to be hearing the case?
That's a good question. So when I think about who would do that, I do think that it should be a neutral party. I think that one of the things that is really contributing to the lack of trust is the narrative or the image of misconduct being investigated by their own. So when police are investigating police on misconduct, that sends us that really hampers the faith in the system, especially when the decisions that are coming back disregard the plights of those that have experienced that misconduct. I would be happy to explore this further and to figure out exactly what that could look like. But I do think that that an independent person should review and look at what's considered compelling and weigh that out and keep in mind the public's interest and their right to know of these situations.
Okay, thank you very much for your testimony. Are there any further questions? Seeing none, thank you very much. Okay, next we're going to have Nancy West.
I believe I unmuted.
You
Good.
are now.
Thank you. Good afternoon. My name is Nancy West, and I founded the New Hampshire Center for Public Interest Journalism 6 years ago. Before that, I worked as a reporter and copy editor at the Union Leader for nearly 30 years. So I've been doing this for a very long time. And we publish, what we do here is we publish the online daily indepthnh.org. We're a nonprofit news website, and we're dedicated to holding the powerful accountable and reporting fair, unbiased news with a strong focus right now on state government and, of course, on COVID. When we report a story here, our reporters, Gary Rayno, Paula Tracy, and myself, we're really representing the people of New Hampshire. We're making sure government officials respect their right to know and ours under the New Hampshire Constitution and the Right to Know law, RSA 91A, by following the law and abiding by the Constitution. And the New Hampshire Constitution, as I'm sure you're all well aware, is really focuses on openness of government. And over the years, I can't tell you how many people have contacted me because they believe they were somehow wronged or mistreated in the criminal justice system, often by a police officer. But were barred from getting more information about the officer because of one exemption under the Right to Know law, pretty much guaranteed that any sustained wrongdoing by that officer and all government officials would forever remain secret. That was a 1993 Supreme Court ruling, which became known as the Fenneman case. And it really, for a very long time, made it impossible to obtain information that would have shed light on government wrongdoing. And this kind of secrecy, I can tell you, over the years caused a great deal of frustration, suspicion, and mistrust. Often people just felt cheated. And the New Hampshire Supreme Court recently, I bring that up because the New Hampshire Supreme Court recently overruled that exemption. And it was just last May in two very important public records lawsuits. One was filed by the Seacoast newspapers and the other the Union Leader. And finally,
Ms. West, I'm gonna just stop you to ask you a question. Are you testifying on Senate Bill 41 or on the next bill, which is Senate Bill 39?
Actually,
I think you're
I should have
testifying
caught
on
that
Senate Bill.
before.
Yeah.
I'm so sorry. I should have caught that. I'm in the wrong hearing. And anyway.
You have signed up to testify on Senate Bill 41.
Well, that was my mistake. I meant to sign up for Senate Bill 39. I'm very interested in both cases, but indepthnh.org, New Hampshire Center for Public Interest Journalism, we hadn't planned on testifying on that at all. I'm so sorry for the confusion.
No, that's okay. Because I reviewed the Supreme Court case, and when you started talking about Fenneman and the Seacoast papers, I go, you're talking about the next bill. So that's okay. This is not a problem. It's always a pleasure to hear from you.
Thank you, Senator.
So we look forward to hearing from you on the next bill.
Okay, thanks.
Okay, thank you. The chair is going to call Gregory Sullivan.
You are able to speak.
Thank you very much, Madam Chairperson and members of the committee. My name is Gregory Sullivan. I'm an attorney representing Union Leader Corporation. And interestingly enough, my testimony on Senate Bill 41 has a lot to do with my testimony on Senate Bill 39, and I certainly understand Nancy West's confusion. Union Leader is in support of Senate Bill 41, but it's the position of Union Leader that Senate Bill 41 is really a reflection of the law as it exists today. Unfortunately, the New Hampshire Police Standards and Training Council does not agree with that position or share that view. For that reason, Union Leader has filed a lawsuit in the Superior Court that's currently pending. We have a hearing scheduled for February 3rd. But transparency and accountability with respect to both of these bills are critical to promoting the trust that's required between the citizenry and the police agencies in order to promote more effective and efficient law enforcement. The New Hampshire Police Standards and Training Council, when moving to conduct the decertification hearing of Aaron Brown, who was mentioned earlier, the police officer in Manchester who was found to have sent racist text on his department-issued phone, we had moved to have that hearing held in public. At the last minute, an attorney for Mr. Brown withdrew the hearing and accepted a suspension of his certification. But on that same agenda, that same evening, was a decertification hearing on another police officer. And I orally, consistent with the rules of the Police Standards and Training Council, moved to keep that hearing open, and that motion was denied and the hearing was held in secret. Secrecy with respect to law enforcement decisions and agencies is just no longer acceptable. The governor's office with the new Lee Act Commission, the Supreme Court with the two cases that Nancy West cited, both of those branches of government are moving toward more openness, more transparency, and more accountability. And Senate Bill 41 will guarantee and ensure that. And very quickly, I know I'm running out of time, but with respect to the question that was posed earlier, the way I would envision that working is a police officer or a police department would suggest that there's a compelling interest outweighing the public's right of access. At that point in time, the council en masse would vote to either have the hearing in public or in private or certain portions thereto. Now, someone aggrieved by that decision, for example, a newspaper, would then have the ability to appeal that decision to the Superior Court, and that's who'd make the ultimate determination as to whether or not the agency's decision was the correct one. So
Okay.
I'll be glad to answer any questions, any committee we have.
Thank you very much, Mr. Sullivan. Are there any questions for the committee, from the committee? Okay, seeing none. Thank you very much for your time this afternoon. Okay, next we're going to call Richard Gagliuso.
Senator, I do not see him in the attendees column.
Okay, we can always come back.
Rick? Is he Rick that just raised his hand, maybe?
Oh, must probably. Should I let this Rick in?
He did sign up. Is it Richard? It's Richard Gagliuso.
He's just listed as being Rick, so there's no way to know unless we let him in and ask.
Okay. All right, we'll have to, we'll talk about how we can do that a little better. And just maybe let people know they have to put their full name. So we have to have that for our records. Okay, why don't we go ahead and let him in and hear what he has to say.
You're able to speak?
Hello.
Hello, is this Mr. Gagliuso?
It is indeed.
Okay, thank you. Just to note a couple of things. In the future, if you wish to sign up to speak on any of these bills, we need for the record to get your complete name. And you have 3 minutes to let us know what you think. Okay, so please go ahead.
Thank you very much, Madam Chairwoman. And I thought I had actually signed up and given my full name and actually some other information. So
just to clarify, Mr. Gagliuso, you did give your full name. We're talking about two separate kinds of signups now. We're talking about the sign-in sheet that Senator Carson was reading off of, and then we have people, how they're listed on Zoom, which is based off of their account or what information they sign in. So on our end, because you signed in on Zoom under just Rick, that's what's coming up.
I think that's right, and I apologize for that. I should have signed in on Zoom the same way. Anyway, let me not take any time to cover those things. I apologize for any confusion. My name is Richard Gagliuso. I'm an attorney in Manchester with the Bernstein Schur law firm. I have been a media lawyer representing newspapers and other media interests since sometime in the mid 1980s and have handled a lot of access to public record type cases. I am here today as a board member and a representative of both the New Hampshire Press Association and the New England First Amendment Coalition. And I don't have too much more to add to what my friend Greg Sullivan just told you, so I'm going to try not to repeat what he said. I will ask you to simply recognize that I echo all of his comments. And I do think this would be an extremely salutary bill in this age of increased transparency and accountability for law enforcement. I wanted to add that I actually am a member today of the hearings committee of the attorney discipline system in New Hampshire. And I sit on panels, hearing panels, which consider ethical complaints and alleged violations by attorneys. Those hearings are all open to the public and they work very well. There aren't too many occasions where the public is beating down the doors of our hearing room, but they are open to the public. It does not inhibit discussion or argument or testimony, and it certainly gives the feeling of transparency and openness to the process. I believe the same is true of the comparable disciplinary processes for judges, for doctors, and other professionals in this state. And it makes no sense to me that police officers would not be handled the same way. This bill, as I read it, would provide a mechanism for people to, the officer in question, presumably, to ask that portions of the hearing be closed to the extent there was confidential information that was likely to be disclosed. I think that's an appropriate balancing of the competing interests in that process. And I think overall, this would be an extremely healthy way to advance the cause of transparency and accountability. So I'm going to leave you. I do intend to come back and chat with you briefly about Senate Bill 39, but unless you have any questions, I'll cede the floor to the next speaker.
Thank you very much for your testimony, Mr. Galucio. Are there any questions from the committee? Okay, seeing none, thank you very much. The chair will call Carla Garricky.
You are able to speak. You're on mute.
Yeah, she's muted.
You have to just,
Okay, there we go.
Hi, thank you, Madam Chair and Judiciary Committee members. And thank you, Jenny, for getting back to me with that link. I know your job is not easy probably currently. My name is Carla Garrick. I'm the former Republican State Senate candidate in District 20. I live in Manchester and I'm an attorney by training and serve on several nonprofit boards, including Right to Know New Hampshire. Right to Know New Hampshire is a nonpartisan citizens coalition that works to improve government transparency, which of course is a crucial component to maintaining public trust in our institutions. I submitted some written testimony and I just wanted to let you know that I'm speaking here in my personal capacity, and other members of Right to Know New Hampshire did also submit their testimony. I'm here in support of Senate Bill 41 because of course it's going to increase police accountability by opening up disciplinary hearings to the public. I think we can all acknowledge, based on what happened last summer, that we understand that without trust in the people enforcing our laws, everything starts to break down. Now, I have to say, I'm very happy to see some appetite for reform finally, because I've been doing police accountability work for
probably 12 years here in New Hampshire. So I'm really excited, and I hope that you guys use this as an opportunity to start to right the wrongs. Obviously, transparency leads to faster reforms. We can't fix what we don't know is broken, and we can't know something is broken if we're doing things in secret. If we hide the truth, we can't fix what needs to be fixed. Opening these disciplinary actions to public scrutiny must happen in order to restore our trust. People will make arguments that the police officers should have some kind of privacy interest. I don't believe that's the case. When police officers are acting in their official capacities, they should be on the job, on the record. As other people have mentioned here, other professions have public disciplinary hearings and the sky does not fall down. Why wouldn't we do that for police officers, especially when we take into consideration the nature of their work? Any disciplinary action before the Standards and Training Council creates a significant and compelling public interest, both with regard to the officer, but something that hasn't been mentioned yet is it also provides the public with an oversight as to the actual training council itself. Based on the numbers of officers with sustained findings of misconduct that are currently being hidden from the public in the Lori's list or the exculpatory evidence schedule, there is an immediate and urgent need for more public scrutiny of this entire process. The LEAC Commission itself also concurs with this, and they recommended under number 22 in its final report that we should make the exculpatory schedule public, and the ACLU and the Press Association, who both testified here, also believe we should have increased transparency and accountability. Obviously, public scrutiny is the best way for us to implement checks and balances to hold our law enforcement officials accountable. It starts with this bill and your appetite to do what's right in the name of restoring public trust. Without trust, everything will crumble. Please don't let this happen on your watch. I respectfully urge you to support this bill, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Again, thank you very much for your testimony this afternoon. Do we have any other folks who would like to speak?
There were a number of individuals, Senator, that signed up after 12:30. So if you signed up after 12:30, I can pull up our updated sheet. If you could just raise your hand.
All right, we have a Tony Gullumren and Asma Aluni raising their hands.
Okay, what is the first person's name again?
Tony, and then the last name is S.C.
Scullambrini. Scullambrini.
Okay, and the other person's name is?
Asma Aluni.
Okay. Okay. All right. So why don't we go ahead and we'll recognize Mr. Scullambrini. And good afternoon, Mr. Scullambrini.
Good afternoon, Madam Chairwoman.
We're going to give you 3 minutes. So please tell us what you think about Senate Bill 41.
Thank you. I'll make it less than 3 minutes.
Okay.
My name is Scullambrini. I run a law firm with my partner, Gillen Scullambrini in Nashua. I'm testifying as an individual in support of SB 41. I'm a lawyer in Nashua. I worked for the public defender. Then I worked at Dave Gotteson's office, and now I work for myself. I've handled thousands of criminal cases in more than 16 years of practice. My experience in the process has made it clear to me that transparency is the key to legitimacy and keeping the faith of the public. SB 41 is an essential part of ensuring that transparency. It makes police officers and their discipline process equal to that of other stakeholders in the criminal justice system. Both lawyers, prosecutors, and defense lawyers, as well as judges, have public discipline proceedings. Making discipline proceedings for police open to the public will put them on par with everyone else. Additionally, as is always the case, Open discipline proceedings benefit the society as a whole. Instead of guessing why things were done, people can go and look at the record and decide for themselves. Over and over again, both in New Hampshire and the United States as a whole, the value of transparency has been made clear. As we see the aftermath of various investigations across the country, both sides of the political spectrum have filled the gap in public knowledge with speculation that only fans the flames of discord. It's important to realize that if police were wrongfully disciplined, an open and transparent process will benefit them and spread the word of their illegitimate discipline. Finally, the bill is careful to make sure that some things will remain private, eliminating the process of discipline, and making sure that the process of discipline is not simply an opportunity to embarrass officers that are politically unpopular in their department, even if they're ultimately cleared of wrongdoing. For these reasons and for the general health of the criminal justice system, I think that a bill like this is absolutely essential, and I think that it will help both defendants and the state in prosecuting cases and defending cases and making sure that justice is done.
Thank you very much for your testimony this afternoon, Mr. Scalabrini. Are there any questions from the committee? Seeing none, thank you again for your testimony.
Thank you.
The chair will call Asma Alhouni. Good afternoon again, Ms. Alhouni.
Thank you, Senator. Again, my name is Asma, like the letter Esma, and then my last name is Elhouni. So Asma Elhouni, thank you for trying, and I appreciate that. Yeah, so again, I am with Rights and Democracy New Hampshire, and I'm gonna keep this very short because I think everyone said what needs to be said, but I am speaking in favor of this bill and just reminding people we can't ignore the many, many people begging for change in our nation in New Hampshire. And so people can and are interpreting this private decertification as allowing people in positions of power to abuse their power, backed by lawmakers that allow it to happen. So you have an opportunity to definitely change that. So police should definitely have higher standards of accountability than all of us versus what's happening now, which is they're getting special treatment in the other direction. And the reason why we should hold them towards greater accountability is because the powerful role they have in people's eyes, right, that they occupy in our communities. So this is not just a good idea, but it's an important move for New Hampshire to take. Thank you so much for hearing me.
Thank you again for your testimony, Ms. Alhouni. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thanks.
Do we have anybody else whose hand is up?
No.
We did have two other people that signed up to speak, Senator, a Joseph Brooks and a Joe Krupski, I believe, but I didn't see them in the sign-in sheet. So if they're calling in by phone, you can raise your hand by dialing *9. I see that we do have one phone number hand up.
Okay, do we know who it is?
No, there's no way to tell when someone calls in by phone.
Okay, well, let's let them in and find out what they have to say, who they are. Hello? Hello?
Hello?
Yes, hello. Please identify yourself
Hello.
for us, please.
Hi, my name's Joseph Brooks. I believe I'm on your call list.
Okay, unfortunately, you're not, but that's okay. We'll make it work.
Okay. I'm a New Hampshire resident, as well as I was born in this state in Manchester, New Hampshire at Elliott Hospital. I'm 37 years old, going on 38, and I absolutely support this bill. I have been a victim of sexual assault as a child, a preteen, a teenager, and an adult, as well as physical abuse and violence by police officials throughout my childhood years and my teenage years, and now my adult years. During this process, I have learned very clearly how easy it is to say I'm wrong and put my head in the sand because I believe superior officials who were wearing the proper uniforms told me I was wrong. And because of that, an innocent man is doing time and I pled out to something I didn't do. This is one of the many atrocities that police are able to enforce and force someone through a public defender system when you're even a teenager at 17 charged as an adult, and they repeal the law and it leaves no recoupance and no way to face it when you're poor and broken and damaged by a system who is let to run reckless with no checks and balances. This is a check and balance that is needed and been needed for a long time. People essentially are good and they won't fight law enforcement, so if they don't have any need to be afraid of the people that they're bringing to justice, then they shouldn't need things like qualified immunity. We are citizens of this country, born here, bred here, and put police in charge to make it better for every citizen, not just their success, not just their rights to get militarized equipment at ease of access. Instead, the systems are being abused to oppress citizens from speaking out, and this is wrong. I have suffered many times at the hands of this system just trying to do the right thing and to follow what was put into place, and it is very confusing and very dissuading and very emotionally disturbing to the family of those that have been damaged by this system. And I'm not alone. I'm one of many, and I'm not even black. I'm Native American. I've had police officers in my own town and state coming to my house to try and enforce laws and rules for something that didn't occur or wasn't a law or a rule right here at my own address, and then turn around and after chasing them off, they're up playing games in Congress and electing and getting things voted for themselves, using their uniform, their representation, doing things that are very inappropriate at the hands of law enforcement. I understand they're supposed to be for the good. I've believed in them my whole life. But everything that has occurred in the 37 years I've been alive is wrong. Okay? I went into a probation and parole office to parole out of a prison. And over the time that I've still been on parole and probation and supervision, I've had state troopers like Trooper Eder Linnell lie in a hearing where I was there months after just getting out with nothing to my name, have her order in a hearing for me to sell a $1,500 piece of borrowed equipment that wasn't mine while the owner was standing there, and tell them that that's how I should pay for the $50 registration fee that I was required at that hearing to pay, or explain why I couldn't. And then the ruling by another officer ruled and allowed it to happen. I still am holding on to a debt to pay my mother for a piece of equipment I refused to sell that I was borrowing. And this is what our police are allowed to do. This is why this is needed. Please.
Thank you very much. I just wanted to make sure that if you had anything additional you wanted to talk about the subject of the bill, which is police disciplinary hearings. Is there anything else that you'd like to add?
Yes. I would like to say that people being allowed to wear their uniform and lie and represent to you people in public, and then get you to vote and rule on what they say, and then hide it. These are the things that transparency causes issues with. These are the things that need to be looked in.
Okay. Thank you very much for your testimony this afternoon, Mr. Brooks. Are there any questions from the committee? Okay, seeing none. Again, thank you very much for testifying this afternoon, Mr. Brooks.
You're welcome, and I look forward to testifying at 39.
Okay, thank you. Are there any other folks who want to testify on this?
You have no hands raised.
Okay, we're going to go ahead and close the public hearing on Senate Bill 41. Okay. Go through the rest of this and we'll be set to go in a minute. Okay, I'm going to go ahead and open the Senate hearing on Senate Bill 39. And I'm going to hand the gavel over to Senator Gannon, who is the vice chair of the committee, because I am the sponsor of this bill and I'll be testifying. After the completion of my testimony, I'll be taking the gavel back to chair the rest of the hearing. So Senator Gannon, take it away.
Thank you, Senator Carson. We're introducing Senate Bill 39, and the Honorable Sharon Carson will introduce the bill.
Thank you very much, Mr. Chairman. My name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Hudson, Londonderry, and Auburn. And I have this afternoon for your consideration Senate Bill 39, which seeks to exempts information and records contained in personnel files, internal investigations, and pre-employment background investigations of any state or local law enforcement officer from public access or disclosure from under the right to know law. Mr. Chairman, this bill was brought forward to bring some clarity and congruity to several statutes and recent case law handed down by the New Hampshire Supreme Court. The recent Supreme Court decisions have overturned the long-held Fenneman decision, has cast doubt on what part of a police personnel file are subject to RSA 91A, our right to know law. This bill is designed to clarify that personnel files, internal investigations, and pre-employment background investigations are confidential and exempt from 91A requests. Personnel files contain confidential information about officers, such as biographical information, home address, next of kin, blood type, and other types of sensitive information. Internal investigations contain statements from the officer that were obtained under his or her garrity rights, which may violate that officer's other constitutional rights if released to the public. There are also potential statements from victims and witnesses that may be both police officers and private citizens. Making those statements public would have a chilling effect on the cooperation of both victims and witnesses. Finally, pre-employment background investigations often contain very sensitive information from an individual's background prior to employment with the department. This may cover topics such as sexual preference, past relationships, medical exams, psychological exams, and other sensitive materials. Again, this would have a chilling effect on recruitment and retention if these files were subject to the 91A request. Recruitment and retention issues have been an increasing concern in the law enforcement community and is especially the time that we need to be supporting our law enforcement officers. We should not be treating them disparately from other public employees because they are the most visible arm of the government. And with that, Mr. Chairman, I will conclude my testimony.
Thank you, Senator Carson. Do any members of the committee have any questions for Senator Carson? Go ahead, Senator Khan.
Thank you, Mr. Chairman. Senator, thanks for taking a question. These records are not accessible currently. So what seems that they're already exempted from 91A?
I'm sorry, Senator, I can't hear you.
All right, I'm not muted. So
no, you're not muted. It's just it's a little choppy and it's not coming through clearly.
We'll try again.
Okay.
These records are not accessible currently, correct?
Correct.
Okay. So and that's because they're exempted from a right to know in 91A, right?
Mm-hmm. Correct. Correct. And okay.
Okay. Well, I guess I that's what I thought as well, but you do feel apparently that it is necessary to reinforce that statement together.
Okay. Thank you. Thank you very much for the question.
Does anyone else have a question? I do. Okay, Senator Whitley, go ahead.
Thank you for taking my question. Thank you, Senator Carson. also taking my question. So, just to clarify, so the law was changed under 2 Supreme Court decisions this summer, correct?
Well, the law itself hasn't changed. It's the court ruling.
The interpretation.
It's the interpretation that's changed.
Correct. Okay, so under the law as it's now interpreted by the Supreme Court, is it the case that, really personal data like home address, health information, that can be redacted, correct?
I'm going to answer this because I've gotten information that the way that the ruling is worded, it really needs some clarity. And there seems to be some sort of misunderstanding about just exactly what type of information we are talking about. And that's why the bill was filed, because this does not only apply to police officers. This applies to any public official, any public person that is working for either a municipality or for the state. So it's just not police officers. It's for any public employee. So I think that's why I filed the bill, because we need to get clarity and consensus when we're talking about this.
Follow up?
Go ahead, Senator Whitley.
But I see your point on that, but your bill only applies to police officers, correct?
Correct. And because I've received information from the Municipal Association, I'm not, yes, they're going to be testifying. They have a lot of concerns about what the effect is going to be on all public and municipal employees. So I think that this bill we can use it, have a great discussion about the interpretation of the court and what we need to clarify.
Thank you for taking my question.
Anyone else? Just a quick question, Senator Carson. Would there ever be a time you would see a balancing test for this information that I'm not thinking?
I hope that we can do something like that, where we can find some sort of a balancing test to put into place. It's just a question of going through the process and bringing all the parties together to come up with something everyone can agree on.
Thank you, Senator Carson. Anyone else? Oh, yes, go ahead, Senator Whitley.
Just a clarifying question. The balancing tests that you're referring to, isn't that what the recent Supreme Court decided, that we should be using a balancing test in the disclosure?
Yes.
Thank you. Anyone else? Okay, thank you, Senator Carson, for your testimony.
Thank you. Thank you, Mr. Chairman. Okay, next we're going to go to Julian Jefferson. Good afternoon, Mr. Jefferson.
Good afternoon. Can you hear me okay, Senator?
Yes, we sure can.
Thank you. So my name is Julian Jefferson. I was a member of the Lee Act Commission. I am an attorney with the Public Defender Office. I'm speaking in my personal capacity, though. I'm not speaking on behalf of the Public Defender Office. So I speak in opposition to the bill because I think the bill is in search of a problem that is not there. So to sort of go off the discussion between Senator Whitley and Senator Carson, I think the concern of Senator Carson is something that the New Hampshire Supreme Court has given an appropriate remedy to it. So this information, a personnel file of anybody is confidential and sensitive. And I agree with Senator Carson that you don't want people knowing your biographical data, your medical information. And I don't think any of that would become available under a right to know request. So the right to know request has to trigger the request, and then the court reviewing it will engage in this balancing test and will not be releasing information that the public doesn't have a right to know. The public doesn't have a right to know somebody's home address or their medical information. But what I think our state and our nation has said quite clearly over the past several months is that the public does have a right to know when people who we are paying as citizens engage in misconduct or have issues with credibility or have a pattern of complaints filed against them for abusive, harassing, or bullying behavior. I think all of that information, that our public does have a right to know. And that should not just be confined to a criminal defendant requesting it or expecting it from a prosecutor under their constitutional obligations under Brady. I think we as a community as a whole also have the right to know and the right to request to see a personnel file. And when I say personnel file, to see only those portions that are relevant. And that was the basis of the Supreme Court decision. At the heart of that decision was the EES schedule that we're referring to. And in the LEAC Commission, we voted unanimously to make the EES public. And that was endorsed by the governor. So this would be at odds with that recommendation because it's seeking to shield the information that was the very subject of the court case that led to this bill being sponsored. So I would just ask the senators to think about, why the LEAC Commission was formed. It was formed about transparency and accountability. Remember that we as a community pay police officers. We give them the guns and the badges and give them all of this responsibility. And the public, through news agencies or whomever wants to request this information, certainly has a right to know if an officer in their community has sustained findings of misconduct or other issues that go to their credibility. And the courts are more than capable of engaging in that balancing test. So this is a bill that seeks to solve a problem that is not there. And if the bill is passed, what it's going to do is going to send a message to the community that secrecy will rule the day. And that is, that to me, that's a dangerous road for us to be going down. So I would urge the senators and the committee as a whole to rethink this and that there is a balancing test that is there and the courts already have that. And to codify that, I don't think would hurt. But the legislation as it's currently written is not that. It's just a complete bar of access to information that the public has a right to know. Thank you so much for your time.
Okay. Are there any questions for Mr. Jefferson? Mr. Jefferson, I'm looking at the particular case, the Union Leader Corporation versus the Town of Salem. And in the case, it does say that they're overruling Fenneman to the extent that it decided that records related to internal personnel practices are categorically exempt from disclosure under the right to know law, instead of being subject to a balancing test to determine whether such materials are exempt from disclosure. It goes on to say the trial court did not apply a balancing test to determine whether the redacted material should be disclosed, but rather based upon Fenneman, ruled that the redacted material was categorically exempt from disclosure. And one of the things that I'd like to do with this legislation is to figure out if we can have some sort of balancing test in place that is going to take personal and private material or information, especially pre-exam, where we're talking about medical exams and psychological exams, the results of those exams, persons, where police officers live. We've seen around the country where their addresses, they've been doxxed and their home addresses have been made public, and other types of public and private information. And what we need to do is figure out a way to balance their need for privacy and something that is going to protect their constitutional rights with the public right to know. Just because you become a police officer doesn't mean you give up your constitutional rights. So this is what I'm hoping that we can do with this particular piece of legislation. Do you have anything that you would like to add in response?
Yes, thank you, Senator Carson. And let me start by saying I 100% agree with all of the statements that you just made. I think this bill, so two comments. One, I think it's premature, the bill, because it needs to be sent back down to the trial court and have the trial court develop that balancing test. And then I think this committee would be in a much better position to see, if the balancing test that is articulated by the Superior Court, and then, if it goes up on appeal again, is then reviewed by the Supreme Court, then I think this committee would be in a much better position then to engage and see if legislation is needed there to codify that. So I 100% agree with you that I, under no circumstances should people be able to get access to somebody's home address, their email address, their medical information, and sensitive information. But what this court case was about was specifically the EES schedule, and the court ruling is saying that the EES schedule is not considered a personnel file. So that ruling doesn't then turn to saying that now the entire personnel file is open to public view. The ruling is limited in the sense that it's just saying that this EES schedule should not be categorically exempt as an internal personnel file. It is not saying that the internal personnel file, which contains all this sensitive information as a result of this ruling, would now therefore become public. So we're not there yet, and I certainly don't think the trial court or the Supreme Court would ever rule in such a broad fashion. So I think it would make sense to let the trial court make its ruling, and I think the committee would be in a much better position to see if there is an issue. But the legislation as it's currently written, I strongly fear will send a message to the community that police officers are entitled to absolute secrecy in everything contained in their personnel file. And I think that is incorrect. And I think that would go against the heart of our recommendation that the EES schedule will be made public.
Thank you very much. Are there any further questions from the committee? Okay, seeing none, thank you very much, Mr. Jefferson, and thank you for the discussion this afternoon.
Yep. Thank you, Senator Carson.
Okay, next we are going to hear from Cordell Johnston.
Good afternoon, Madam Chair and members of the committee. I'm just going to keep talking until you tell me that you can't hear me.
Okay.
I'm Cordell Johnston, Government Affairs Counsel for the New Hampshire Municipal Association. Here in qualified support, I would say, of this bill. And I did send an email to Senator Carson over the weekend suggesting a couple of things about the bill. And I guess I'll tell you first the things that I think we would like to see changed, and then explain why we do think that legislation is necessary. I think it is hard to take the position that records related to a determination of misconduct should be exempt. And I understand the concerns that you've already heard and will hear from other parties, that when a police officer or another employee has been found to have engaged in misconduct, I think generally those records should not be exempt from disclosure. So in that respect, I think the language of the bill is a little too, goes a little too far, in that it would seem to exempt all personnel files, all police personnel files from disclosure. On the other hand, I think the language is a little too narrow in that it applies only to police personnel. We would like to see language that addresses all public employees. So those are the things that I would suggest changing. Our reason for generally supporting the intent of the bill is, you've already heard about the balancing test, and the prior witness said that courts are quite capable of applying a balancing test. But the problem is that it's not the court in the first instance that is going to have to apply this balancing test. It's going to be a town manager or a city manager or a police chief or someone else who, every time they get a request for personnel records, they're going to have to compare, and what the test is, you balance the employee's right to privacy, interest in privacy, against the public's right to know. And there is a balancing to be done there, but it's clearly very subjective. And so every time a municipality gets one of these requests, they're going to have to engage in that subjective balancing test. And every time they do that, that's going to be subject to challenge in court. And so that's why we think you can draw the line. People can disagree on where the line should be drawn, but it would be very helpful to have in statute a statement of what is exempt and what is not exempt. And I realize that won't answer every question either, because that will still be subject to interpretation. But you know, it was very easy for the Supreme Court to say, apply a balancing test. Well, if you're 5 justices of the Supreme Court and you have 9 months to issue a ruling and think about it, that's fine. But if you're an HR director and you have to make a decision in a couple of days, it's not quite that easy. So we really would like to see something that makes it much clearer and simpler to apply at the municipal level. And that's all I'll say unless anyone has any questions. Thank you.
Thank you very much for your testimony this afternoon, Mr. Johnston. Are there questions from the committee? Senator Khan.
Thank you, Madam Chair. Thank you, Mr. Johnston, for taking the question. The question is, isn't the balancing what the current state, the balancing you described between the public's right to know and the confidentiality of personnel records, that balancing test is in fact what is the basis for decisions today, right?
Since the Supreme Court's decision last May, that is, yes, that's the state of the law now, is that a balancing test has to be applied, and then whoever is applying the balancing test makes a decision as to whether the record should be disclosed. And that's our concern, is putting the local HR director or town manager or whoever in the position of having to apply that balancing test and essentially be a judge every time they get such a request.
I believe, Mr. Johnson, we've seen that this kind of legislation trying to work on this in the past.
Do you have a further question, Senator Khan?
Mr. Johnson, I know attends a lot of hearings. We've seen that this interest in having the legislature determine what the courts currently are determining relative to balance, haven't we?
I'm not sure actually we've seen this this kind of legislation. Certainly we see a lot of bills dealing with the right to know law. And I guess our view is it would be good for the legislature to establish the policy here rather than have it established on a case-by-case basis by superior courts and the Supreme Court.
Thank you.
Are there any further questions for Mr. Johnston? Okay, seeing none. Thank you very much for your testimony this afternoon, Mr. Johnston.
Thank you.
Okay, the chair will call Nancy West.
Hello again.
Good afternoon again.
Yes, thank you. Sorry about the confusion earlier.
That's okay.
I'm Nancy West. I'm the founder of New Hampshire Center for Public Interest Journalism. We publish online daily, indepthnh.org. And we have a special interest in this particular bill, Senate Bill 39, because we're the lead plaintiff in another case that the Supreme Court has recently heard relative to the Lorry list. I think it's called now the exculpatory evidence schedule. And in that case, the New Hampshire Center for Public Interest Journalism and 6 other news outlets argued before the Supreme Court, actually argued before the Superior Court that ruled it was not a confidential document. And the Supreme Court agreed, but has remanded it back to the Superior Court for Judge Temple to determine whether or not police have privacy issues, privacy rights, in whether or not this document will be released. And what the document really is, it's the names of 280 plus police officers who have in their personnel files evidence of sustained misconduct. This isn't just a phishing search. This is officers who have been determined and had a chance to get off the list, and it's been a secret list for many years. When I first started covering this as a reporter, it wasn't in the daily lexicon. Most people outside the legal community had no idea that there was a secret list that contained the names of police officers who had a propensity for dishonesty to the degree that a prosecutor may be required to turn that evidence over to the defendant in a criminal case. That's a constitutional guarantee that all defendants get all rights favorable to them. But you'll hear from, I think you'll hear from legal experts who understand that part of the law much better than I do. But I can tell you, I have people calling me as a reporter regularly, waiting and anticipating to get the lorry list, the EES schedule made public. Why is that important? Because if there is a dishonest police officer who testified in their case, they may have a right to seek a new trial. I mean, these are very important matters to not just the past criminal defendants, but criminal defendants going forward, and, you know, as far as the lorry list is. And the Supreme Court has ruled it's not a confidential document. It's just a matter now of determining privacy rights. My opinion would be a police officer on the job has no right to secrecy for wrongdoing in their personnel file. I hope this bill doesn't go forward because it would really, I think, cause people to really lose trust in public officials. Most police officers are very honest in doing their jobs. And in reporting over the years about dishonest police officers, I can tell you that I often got phone calls from, police sources who would say, good, we don't want bad cops out there. Nobody wants bad cops out there, and nobody wants to believe that there's more than a very small percentage. I know my uncles both worked as police officers in the Taunton Police Department for decades. And, just hearing the stories, the trials and tribulations, even then, which are much more, I would guess, serious now because of the nature of, just being a police officer, I think, is more dangerous today. And I think this is a very, it's a bill that I think wants to protect police officers, but I think it also does a disservice to them because I don't think that the kind of police officers we want on the streets want to keep secret any misconduct by their peers. I know there's been cases in New Hampshire where police officers have turned in other officers for doing wrongdoing. And I think that was part of the Lee Act Commission. In this day and age where we're really focusing on racial justice, the Lee Act Commission really took a lot of major steps and made, I think, something like 40 recommendations for reform and things that all of the police officials on that commission also supported. I think it's been very clear through the Lee Act Commission that's what's needed is more transparency, not more secrecy, if we're going to make sure people trust the criminal justice system and the police when they get stopped. And they have a right to know that. The citizens pay police departments. These are public officials. They shouldn't be singled out for special secrecy when they are probably the public officials who have the most serious impact in an average person's life. They have the right to take away a person's liberty and arrest someone. I mean, that's huge. This isn't just somebody that's a government official who doesn't have that kind of right. These are people, and Greg Sullivan talked about this at the Supreme Court. These are the people who carry guns and badges and have so much power over our lives that we need to make sure they are held accountable. And so I oppose Senate Bill 39. I think it should just hit the dust.
Okay, thank you very much for your testimony, Ms. West. Are there any questions from the committee? Senator Gannon?
Hi, Nancy. Thanks for taking my question. Just so it's internal investigations seem to be the part that you're concerned with. If you looked at it from a police officer standpoint and there was an unfounded investigation, now I'm tainted, that comes out and I've never really done anything wrong. Do you have any concern for the police officer?
Oh, I really do. I do not think that a police officer who has unsustained misconduct is what we're talking about. When in 2017, when the Attorney General rewrote the some of the Lori memo, the Heed memo, they took into consideration the need to have all officers have the right to get off the list. I know there's been talk over the years about officers who were not notified immediately or never notified that they were even on the list. I don't know how that can be possible, but it happens, you know, stuff happens. So that's not what the Lori list, or I don't think any other investigation or news outlet is going to be interested in for unfounded allegations. These are founded allegations that are of a serious nature. I don't think anybody's looking to get information about a police officer who wasn't wearing his hat at a certain ceremony. I don't know if you've had a chance to look at the Lori list. It is much redacted, but it lists a great many different offenses that landed police officers on the list. And they're, you know, some of them are downright criminal. So you wonder why, if this person committed that perjury, for instance, why wasn't that individual prosecuted in court? It raises a lot of issues, and some of them, most of the people that I've seen on that list, some of them are so vague you really can't tell what they were. It just says things like untruthful or dishonest. But I mean, there's assaults, criminal behavior that's mentioned on these Lori lists. Of course, the names are redacted. The departments where the individual officers work, those are listed in most of the cases, but we don't know the dates that these incidents happened. And, you know, I think when you have a Superior Court judge and the state Supreme Court rule, the Lori list is not a confidential document. I think it's time that be made public and that we do not provide rights that I don't think will even benefit the police.
All right, thank you very much. Is there any further questions for Ms. West? Okay, seeing none. Thank you very much, Ms. West. Okay, next we're going to go to Larry Vogelman.
Am I unmuted? Yes. Good afternoon, Madam Chair, members of the committee. My name is Larry Vogelman, and I'm an attorney at Gordon. And I've been practicing criminal defense, civil rights litigation.
Mr. Vogelman, you're kind of choppy. It's a little difficult to hear you.
Okay, is that better?
Let's give that a try.
Okay. So I've been practicing criminal defense and civil rights litigation for almost 50 years. I know that Senator Carson and the opponents of this bill think that this bill is a bill that's
Mr. Vogelman, I'm sorry, but it's very garbled. It's not clear at all. Is there another way that you can perhaps speak with us? I don't know if the connection might not be working too well, but we just really can't hear or understand what you're saying.
Let me see if I can change the settings here. Is that any better?
That sounds a little clearer.
I'll try to also talk slower. Somehow,
Okay.
being from New York, that is an issue. In reality, my opinion is that this bill would hamper law enforcement. When I was a law professor, one of my areas of study was law enforcement. And one of the things that helps law enforcement is the community believing that police officers are fair, their actions are transparent, and that if people do something wrong, even though they're police officers, there are consequences. I'm privileged to practice civil rights litigation all across the country. And I am proud to say that the police officers in New Hampshire far and away commit much, much, much fewer acts of misconduct than almost anywhere in the country. And I'm also proud to say that I get complaints from people about police conduct 10, 15 a day. And my complaints that I receive are against maybe less than 5% of the police departments in the state. Most police departments in the state, in my 23 years doing it here in New Hampshire, have gotten no complaints from. And a lack of transparency creates this false illusion here and to the rest of the country that we can't trust the police. They hide behind secrecy. They're getting special treatment. When in reality, the more we know about police officers here in New Hampshire, actually, the happier the citizens would be. There are a few bad departments, there are a few bad apples. Usually, police officers here in New Hampshire get it right. And the more transparency there is, the more the public will realize that they're getting it right. And if the public can be on the side of the police rather than knee-jerk against the police, it makes a police officer's job much easier. And I actually got on this hearing at 1:15, so I've listened to a lot of other related topics, and I'm proud that I'm in New Hampshire because here in New Hampshire, we're dealing with the issue of transparency. We're dealing with the issue of relooking at police conduct. And while the other bills that were introduced and debated prior to this one are in support of that transparency, are in support of that reevaluation of police misconduct, this bill actually runs in opposition to that trend, and I think is a bad trend for New Hampshire. And so I am in opposition to the bill.
Thank you very much for your testimony, Mr. Vogelman. Are there any questions for Mr. Vogelman? Okay, seeing none, thank you very much.
You're welcome.
I think at this point, Jenny, how long has this public hearing gone on? Has it been about 40 minutes? Jenny, you're.
We started at 2:49, so
Okay.
yeah.
Yeah, it's been about 40 minutes. Okay. At this point, I think I'm going to go ahead and do the 3-minute rule again, just because we have one more bill that we're going to be hearing this afternoon. Let me get the clock up here and we'll get started. Okay. The next person on the list is Gregory Sullivan. Good afternoon again, Mr. Sullivan.
Good afternoon, Madam Chairperson and members of the committee. And thank you.
I hope you heard that we're going to be doing the 3 minutes again. And I'm going to ask you, please don't repeat things that others have already told us.
I will do my best.
Thank you.
Particularly with respect to the 3 minutes. I submitted written testimony this morning, and accompanying my written testimony was an editorial that appeared in today's Union Leader, and I should say I'm an attorney representing Union Leader Corporation. So the editorial in today's Union Leader I submitted, and I submitted the testimony of Charles Perkins, who was the managing editor of the Union Leader back in 1992 when the House was considering a similar bill. So I'd ask members of the committee to please read those 2 documents. I'm going to say that accountability and transparency are the fundamental pillars of a healthy democracy. Openness and transparency in government action are mandated by New Hampshire's Constitution and its right to know law. I'd like to give a quote that Justice Andrew Shulman of the Superior Court gave in the case of Union Leader versus Town of Salem, which has been discussed already. Justice Shulman wrote, "The audit report proves that bad things happen in the dark when the ultimate watchdogs of accountability, i.e. the voters and taxpayers, are viewed as alien rather than integral to the process of policing the police." With respect to legislation, Union Leader strongly opposes and vehemently opposes this Senate Bill 39. We have a statute in New Hampshire, RSA 91A5, which exempts from disclosure internal personnel practices, confidential commercial or financial information, and other files whose disclosure would constitute invasion of privacy. That is already the law. I had the misfortune of arguing the Fenneman case before the Supreme Court in 1993, and I had the honor and the pleasure of arguing 3 cases before the Supreme Court in 2020. Union Leader versus Town of Salem, Salcetti versus the City of Keene, and Nancy West, who told us about her organization and 6 other media organizations that sought to expose the Laurie list or the EES schedule. The key question to be answered when weighing the potential passage of this bill is this: does a police officer have a reasonable expectation of privacy regarding the performance of his or her public duties? The answer is no. The courts are the proper venue for the balancing test that the Supreme Court discussed in May of 2020 in 3 decisions, but that's been in effect here in New Hampshire since at least 1972, the case of Mans v. Lebanon, where we all got to learn about the salaries of public school teachers. In 1996, the Supreme Court of New Hampshire, in dealing with very similar issues, Union Leader versus the City of Nashua, said when the balancing test is put into place, the question becomes, will the disclosure of the information sought shed light on the performance of a governmental agency or actor? If the answer to that question is yes, privacy takes a back seat. Nobody's looking for medical, sexual, intimate details of a police officer's life.
Mr. Sullivan, we've hit the 3-minute mark.
Thank you very much.
Thank you, Mr. Sullivan. Are there any questions for Mr. Sullivan? Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question, Attorney Sullivan. So I just wanted to flesh out a little bit more about what we heard from the Municipal Association about, you know, the use of this balancing test. So my first question is this balancing test already being used in the courts right now?
Absolutely. It's been used, as I said, by the courts since 1972. And what we've gotten from the Supreme Court over the years is guidance on how the test is to be applied. Now, the Fenneman decision, the Supreme Court in 2020 said was a remnant of an abandoned doctrine. Because what Fenneman did, it made a per se exemption. And that's exactly what Senate Bill 39 seeks to reintroduce. while the Governor's LEAC Commission and the Supreme Court have taken tremendous steps in 2020 towards disclosure and the public's right to know what the government is up to, this Senate Bill 39 is a giant leap in the opposite direction. It promotes the cloak of secrecy as a per se rule, which the Supreme Court, I would suggest, has ruled would be unconstitutional under Part 1, Article 8. This Senate Bill 39, if ever passed, would be challenged in the courts as an unconstitutional violation of both Part 1, Article 8 of the Constitution and 91A, our right to know law. One merely needs to read the preamble to 91A to understand that the proper direction is light. As Justice Brandeis said, sunlight is the best disinfectant. And I want to make the point, 90-something% of police officers and other government officials are doing their job very well every day. And to respond to one question from Senator Cannon, disclosure of information about a police officer being exonerated, showing that they're doing a great job, is just as helpful to the public and to the police as is the disclosure of misconduct. In fact, in the case of Union Leader versus the city of Nashua, it was ultimately disclosed that the police had done a great job, and the Union Leader was able to report on that. So it's not just bad conduct that we seek, it's also good conduct, and that goes for the the certification and the decertification hearings we talked about earlier today. But the point is, all police officers, all corrections officers are our agents and are accountable at all times to the citizenry. That's what our Constitution demands. And the courts balance.
Follow up?
So with the courts, applying this balancing test, isn't it correct that private information, addresses, medical information, the names of private citizens, all that very personal information, is it true that that information is not being revealed right now because there's no public interest for anyone to know that?
The key word is redaction, and government officials do it every day. Courts, if someone challenges the redaction, get to look at the document in camera, that is just the court looking at an unredacted version, and then makes a decision applying the balancing test whether the information will shed light on the performance of the governmental agency or actor. And if that information won't shed light on the performance of the government, then it's not disclosed. And courts do that every day. And that's what the statute and the Supreme Court case law calls for. We have the laws in place right now, and this Senate Bill 39, as I've said, I think would be a giant leap in the wrong direction. And
Are there any further questions?
I might add.
Are there any further questions? Mr. Sullivan, I have a question for you. You've mentioned more than once the LEAC Commission. Has the LEAC Commission finished its work?
The LEAC Commission has not finished its work. And my understanding is not only is it ongoing, but as Nancy West mentioned, the same goal that the LEAC Commission is headed for is currently before the Supreme Court. Justice Temple, the EES case being sent back from the Supreme Court to the Superior Court for the Superior Court to apply that balancing test. So it's kind of a race whether the legislature or the courts will require disclosure of that EES schedule, but they both set the same goal.
Okay, my second question concerns the makeup of the LEAC Commission. Can you tell me if law enforcement is representative on that commission?
I know that law enforcement is, but I am actually not privy to the actual membership as we speak. But I think there's a wide variety of officials involved, certainly including representatives of the Attorney General's office.
Okay, thank you. Are there any further questions? Seeing none, again, thank you very much.
Thank you all very much.
Okay, next we're going to call Richard Gagliuso?
You're able to speak?
Thank you very
And
much. Thank you very
just
much,
to-
Madam
Just
Chairman.
to remind you, Mr. Gagliuso, you have 3 minutes. So,
Thank you.
thank you.
I do understand, and I'm going to try to use less than that.
Okay.
Again, my name is Richard or Rick Gagliuso. I'm a media lawyer like Greg Sullivan, board member of both the New England First Amendment Coalition and the New Hampshire Press Association, and I'm appearing in opposition to this bill on behalf of both organizations. I have submitted some written testimony to each of you this morning by email. And I'm going to, in the interest of time, I'm not going to repeat that, but I am going to ask you respectfully to go to it and review it if you would. It really represents my best effort to distill my thoughts about this bill. I was the attorney who briefed and argued the Seacoast Newspapers case that was decided last May, which in fact overruled this Fenneman decision that's been discussed today. I'm very familiar with the current state of the law as a result of that decision. The companion case, Union Leader Corporation in Salem, shed some light on the internal personnel practices exemption, which I don't think is going to come into play very much anymore because the court has narrowed the scope of that exemption so much. But here's my point. I'm concerned by listening to the hearing today that there is some confusion, respectfully, on the part of the members of the committee about not only what the court did last May, but what the current state of the law is and how workable it is. And so I would like to offer you to call me or contact me by email at the address and phone number that I was on my email this morning. And I would be more than happy to walk you through any of your issues and concerns about what the law is today. The only other thing I want to say is I want to respond to a comment by the representative of the Municipal Association about this balancing test being somehow unworkable because cities and towns need to conduct that balancing test in the first instance. The balancing test, as Greg Sullivan said, has been around for a long time, and it applies to a lot of different categories of information. Cities and towns have been using this balancing test for a long time. The courts have in fact refined it and provided guidance on what it means. And we aren't asking anything more today in asking them to conduct the balancing test in the first instance than what they've been doing for years. It is entirely workable. It's an entirely reasonable thing to ask of them. And obviously, if they get it wrong or someone thinks they got it wrong, they may end up having to have that decision reviewed by the Superior Court. But it's an entirely workable test. It is in place today to alleviate any doubt. It's in place today with respect to the categories of records that are the subject of Senate Bill 39.
Thank you, Mr. Gagliuso. We're at the 3-minute mark.
Understood. Thank you very much.
So thank you very much, and thank you for the offer to the committee members to be able to reach out to you if they have questions. We are in receipt of the email that you sent to us this morning and the editorial. So I would urge the committee members to please read the testimony and the editorial, and if they have questions, to take you up on your offer.
Thank you very much, Madam Chairman.
Thank you. Are there any questions for Mr. Gagliuso? Senator Whitley.
Thank you, Madam Chair, and I appreciate you taking my question. Just on that issue about, because I think this is an important issue to understand, the issue of that the municipal staff is going to be the one who is applying this balancing test in the first instance. And I understand from Rick that they're already doing this. But I'm curious whether he thinks they are sort of, uniquely suited to do this, or whether, other folks are unique to do that.
I'm sorry, whether or not municipal staff people are uniquely suited to do that balancing?
Correct. And to review that private information.
They may be uniquely suited to do it because they, I think, have they are likely to have a good handle on the competing interests at stake here. I think most of them are sensitive to the public interest in the kind of information we're talking about. And I think most of them are used to dealing with issues of privacy with respect to employees of public agencies. So they are in a very good position to do it. I can tell you, Senator Whitley, that I have had at least one case since last May where a city in New Hampshire tried to decline to conduct the balancing test in the first instance and just punted it to the court, said, look, you decide. And the court, I think, correctly sent it back, or not sent it back, but dismissed the case and said, no, we really think it's up to the city in the first instance to make that analysis. Come back to me once you've done that if anybody's not happy with the way they do it. But whether or not they're uniquely equipped to do it, they certainly are equipped, and they're certainly able to do it. There's a lot of guidance today on what constitutes a protected privacy interests, what the public has a unique interest in. These people aren't writing on a blank slate, and so this is not a heavy lift for cities and towns.
Great. Thank you very much, and thank you, Mr. Gagliuso, for your testimony today.
My pleasure. Thank you.
Jenny, can you tell me how much time do we have? Is there a time that we have to be finished?
Technically, since no one's coming behind us, it would be the same as if we were in the State House.
Okay, I didn't know if we had to be done by a particular time. Okay, good. So let's move on. The next person we have that is signed up to speak is Ronell Tashila.
Hello, can you hear me?
Yes, we can, Ms. Tashila. I'd just like to remind you that we are running late, and we've limited everyone's time to 3 minutes. And we're going to ask you please to not repeat testimony that we've already heard.
So my name is Ronell Chella. I'm co-founder of Black Lives Matter Manchester. Unfortunately, some of this information is going to be repetitive, but we are an important voice in this topic, so I'm going to read my testimony as is. Last summer, in the wake of the killing of George Floyd, we organized a number of demonstrations aimed at raising awareness in the issue of racial justice, with the hope that substantive change would follow. Soon after, I was appointed to the New Hampshire Commission on Law Enforcement Accountability, Community, and Transparency, otherwise known as the LEACT Commission, where I got the opportunity to hear testimonies from experts, officials, and community members. While there were several points of contention, one thing was made abundantly clear, and that is that New Hampshire is not innocent, and there's a need for police reform in the state of New Hampshire. Laws that promote secrecy and mistrust need to go. So based on this, we made several recommendations regarding the handling of police records and police misconduct. Furthermore, Black Lives Matter Manchester submitted a right to know late last year in regards to a police officer by the name of Aaron Brown. I know somebody talked about that earlier, who made blatantly racist comments that needed to be brought to light, including a joke made about shooting Black people. Fortunately, we were able to access the records from these proceedings, but with SB 39, we would not have been able to. This bill undermines the efforts of both BLM and the LEACT Commission. So when we heard that SB 39 was being considered, we were disappointed, not surprised. It provides a perfect avenue for bad cops to be protected. In a time where we are so deeply polarized and should focus on rebuilding relationships and trust, it is irresponsible to even consider such legislation. And this bill is an enemy to both accountability and transparency. Furthermore, I'd like to respond to a comment that I heard earlier. Becoming a police officer doesn't mean that you give up your constitutional rights, but it does mean that you have a duty to protect and serve. And should you fail severely in your duties as a public servant, the community should have the right to know. Furthermore, I do want to recommend that the members of this committee actually look at the recommendations put forth by the LEAC Commission, because from the conversation that I've heard here today, it sounds like those haven't even been looked at by some people. And I think that that's a bit worrisome to me, considering that this is being considered. There's still such a long way to go, and we cannot begin to backpedal on the progress that's already been made. And as advocates for racial justice, fairness, and equity in the state of New Hampshire, Black Lives Matter Manchester strongly opposes this bill, and we encourage you to do the same. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? I have just a quick question. The previous speaker, Mr. Gagliuso, when asked, said that the work of the LEAC Commission has not been finished.
Yes, the LEAC Commission has set forth a list of upwards about 40 to 50 recommendations. So our formal meetings have already concluded. The governor released an executive order a few months ago that highlighted the beginning of those recommendations being put into place. The rest of them have either have yet to be enacted. However, all of the recommendations have already been put forth. All of our formal meetings are already done. And to answer a question that you had earlier, several police members of law enforcement were included as members of the commission, members from several police unions. So it was about half and half community members. Well, there was like 2 community members, members from different organizations, and I want to say at least 7 members of law enforcement.
Okay, I can tell you that it was my understanding that, again, that the work of the commission was not finished. And I think that's why a lot of us haven't seen all the recommendations, because we expect that there was probably going to be more in a finished report. So I will just say that. Are there any further questions for this witness? Okay, seeing none, thank you very much for your testimony this afternoon. Okay, the next person that I have testifying, there is no name. It just says victim of violence by local police in New Hampshire, anonymous. Do you have that?
I don't see anything on the attendees unless they're calling in with a phone number.
No, because there's no, they didn't give a phone number or anything else. So is there anyone like that that's in the waiting room?
There is not that I can see. Everyone has a name, or it's just a phone number.
Okay, we'll move on at this point. We're gonna call, the chair will call Wanda Durea.
Yes, can you hear me?
Yes, we can. Good afternoon, Ms. Durea. I would just like to remind you that everyone is getting 3 minutes. So please try not to repeat testimony that we've already heard.
Thank you, Senator Carson.
Thank you.
So what I've been thinking as I've been sitting here, and I'm opposed to the bill as it is written. I don't believe that any police officer's address, blood type, medical information should be released. However, looking back to what I had read on the Lori decision, Officer Adam Lero, part of the information that was released to Lori was actually his misconduct in another state. And that would have been in his pre-hiring interview. So that would be in his personnel files, that the defendant, Lori, would have been entitled to that information that actually resulted in him having another trial. I believe Lori was on trial for murder. So I think that the specific things that you're exempting in this proposed law, are exactly contrary to what should be allowed. I think you should be more specific to say you cannot have their blood type, you cannot have their medical records. Even the unsustained allegations for police officers, if a police officer has 35 unsustained allegations of excessive force, that might be an insight into some actions that he is taking that maybe the Police Standards and Training Commission should look at. So again, I absolutely oppose this legislation.
Thank you very much for your testimony, Ms. Dorea. Are there questions from the committee? Okay, seeing none. Again, thank you very much.
Thank
The chair will call Carla Garrick.
Hi, thank you, Madam Chair and all committee members. I'm Carla Garrick, and I'm going to race through this. Right to Know New Hampshire has definitely submitted their position, and they oppose this bill, Senate Bill 39. I, in my personal capacity, also oppose this bill. For more than a decade, I've been working on police accountability issues in New Hampshire, starting with my own arrest in 2010 for filming police officers during a routine traffic stop. After all charges were dropped against me, I filed and 4 years later won a landmark First Circuit First Amendment court case affirming the right to film police officers in public. Because of my determination to create a binding legal precedent to ensure that citizens can, and I argue should, record police officers in the execution of their public duties. More than 13 million people in the First Circuit can now legally record police officers. Indeed, the court found that the right to film police officers was so clearly established, they can no longer invoke qualified immunity as a defense. It is undeniable to all of us here today that the recording of the police brutality and excessive force that we are seeing today highlights a very serious problem in our country, and that we need more and not less transparency and accountability. I bring out my court case because before there was video evidence of this kind of police misconduct, people like you and police officers and the unions all claimed there wasn't a problem. The reason we're having this discussion is because for the first time, we as citizens can prove what is happening out there. You know, my officer lied on my police report, and someone on a committee at the State House asked me, how do you know he was lying? And I was like, because I was there and literally everything in the police report was falsified and it was a lie. So I experienced it myself. So my point is, we've testified here on bills where everyone seems to be in agreement that we should have more transparency, more openness, and more accountability. This bill actually reverses all of that, and quite frankly, I think is an insult to the citizens of New Hampshire. This anti-accountability bill tramples on the New Hampshire Constitution. It's unconstitutional and violates the Constitution under Article 10, which says we cannot create a separate class of people, which this bill does, because it says only police officers' personnel records will not be subject to disclosure. It also violates Article 8, which in its preamble says the openness in the conduct of public business is essential to a democratic society. The purpose of this chapter, the Right to Know chapter, is to ensure both the greatest possible public access to the actions, discussions, and records of all public bodies and accountability to the people. I want to address a couple of red herrings I've heard. First of all, the whole thing about the doxing, that wouldn't happen because most of the information that we're talking about is information that relates to officers' official and public conduct. It doesn't, so they don't have a compelling privacy interest there. The argument about the unfounded claims, so someone's going to file an unfounded claim. Police officers, by their very nature of their job, they're supposed to investigate criminal things. So I'm pretty sure they can figure it out and investigate things and say that, you know, this was unfounded, so that person should or should not be on the list, or their personnel records should be disclosed. Someone mentioned, you know, some of this behavior is actually downright criminal. I believe that was Nancy West. Yes, some of this behavior is downright criminal. So let's stop hiding it from us. You know, people love to throw around the quotes. It's a Goebbels quote, so I wouldn't say it's a great one, but the police like to say to us, if you have nothing to hide, you have nothing to fear. So I say in return, if they have nothing to hide, they have nothing to fear. We should not support this bill. It's a step backwards. Fetterman took 27 years to overturn. The wheels of injustice roll slowly, slowly, slowly. Let's not step back. Let's keep moving in the positive right direction with lightness, truth, and hope. Thank you.
Thank you very much, Ms. Garrick. Are there any questions from the committee? Okay, seeing none, thank you again for your testimony. The chair will call Catherine Cooper. Good afternoon, Ms. Cooper. I'm just going to remind you that we're doing 3-minute time on testimony, and I'm going to ask you to not repeat what we've heard already. Thank you.
Thank you very much, Senator. My name is Catherine Cooper, and I'm the Executive Director of the New Hampshire Association of Criminal Defense Lawyers. Because there are some committee members who've not heard from us before, I would just like to quickly point out that NHACDL has more than 250 attorney members from around the state. We have a small legislative program, and we try very hard to get our members who specialize in different areas of criminal law to appear before you and share their expertise. I would also encourage any of the committee members or staff members who have questions about the criminal justice system to reach out to me, and I can put you in touch with a qualified expert in your community. As far as our position on SB 39, we strongly encourage this committee to ITL this bill. This proposal flies in the face of recent efforts to increase transparency in the law enforcement profession, and it furthers the exceptionalism that is granted time and again to the police, the kind of favoritism and special treatment that leads to distrust by the public. There are no public employees in New Hampshire who get to hide their personnel files and be completely exempt from 91A, and the police should be no different. I'd also like to point out that many of our professions in New Hampshire maintain systems of self-regulation, and they do so very successfully. Most also have components that are confidential, but also have public access to findings, and particularly once any kind of a hearing starts. But the police as a profession have proven that they are not capable of sufficiently self-monitoring in their practices of hiring, firing officers, or dealing with problem employees. Therefore, they should not be given increased means to hide problems and to protect officers from scrutiny. I also did just send an email to the committee that contains the final report of the LEAC Commission. And I'd like to point out that 50% of that commission was made up of law enforcement. So the commission has submitted its findings. And when it was said that their work is not done, I believe that attorney just meant that not everything that was recommended or endorsed by the governor has taken place yet. So for these reasons, as well as the bases that were articulated earlier by Julian Jefferson and Larry Vogelman, who are two of our members, we would ask that this committee ITL this bill. Thank you.
Thank you very much, Ms. Cooper. Are there any questions from the committee? Okay, seeing none, thank you. I've gone through the list that I have. Are there people who have their hands raised? Jenny?
So, Senator, we have a number of people with their hands raised, and I believe I have about 6 or 7 people that signed up after 12:30 that I can either give you their names, or we can just ask that people, if they're still here and signed up or want to speak, just raise their hand. It's up to you.
Why don't you give me their names, please?
Okay, so we have Chief Anthony Bean Burpee.
What was that again? Sorry, the alarm went off.
It's okay. Chief Anthony Bean Burpee, B-U-R-P-E-E.
Okay.
Then we have John Krupski, that's K-R-U-P-S-K-I.
Okay.
Ozma Eluni. I'm trying, and I'm sorry for butchering that a bit. Then we have Jasmine with a Y, Doby.
Is that D-O-L-B-Y?
D-O-B-E.
Okay. D-O.
And then we have Scott Tradutt, T-R-A-U-D-T.
S, okay, S-C. Oh, I can't even write anymore. S-C-O-T-T. Could you spell that last name again?
T-R-A-U-D-T.
Okay.
And then we have Tristan with a Y, so T-R-Y-S-T-E-N. McLean, that's M-C-C-L-A-I-N.
Okay.
Then we have Jerome Trudeau, T-R-U-D-E-A-U. And
Okay.
that is all that I have at the moment on the list. And I think there are different individuals as well that have their hands raised.
Okay, how many people have their hand raised?
1, 2, 3, 4, 5, 6, 7, 8, but that's a mixture of people that I gave you names of, and I think a couple that weren't on there as well. But I think the majority are people that I gave you the names for.
Okay. All right. Okay, let's start with Chief Anthony Burpee.
Hi there, can you hear me?
Yes, we can, Chief. I'm going to tell you what I've told everyone else. You have 3 minutes, and please do not repeat testimony that we've heard.
Thank you, Madam Chair and members of the committee. My name, as you said, is Anthony. My last name is Bean Burpee. I'm the police chief here in Guilford, New Hampshire. I've been in law enforcement currently for 23.5 years. I spent 16.5 in Maine and then came to take the chief's job in 2014 here in Guilford. I also currently serve as the president of the New Hampshire Association of Chiefs of Police, and I'm here to testify in support of SB 39 as written. I've been sitting here listening to the testimony. I know there's a lot of passion from people out there. So as a stakeholder at the LEAC Commission, we do support transparency in law enforcement. We absolutely believe in being as transparent as possible while at the same time protecting the privacy interests of our employees. As has been said, RSA 105.13b subparagraph 3 states that a personnel file of a police officer shall not be opened for the purposes of obtaining or reviewing non-exculpatory evidence. And 91A5 subparagraph 4 provides an exception for the disclosure of other files where the disclosure would constitute an invasion of privacy. Further, the New Hampshire Supreme Court in 2016, in their case of Gantert versus the city of Rochester, said that there is an interest in one's reputation, particularly in one's profession. It's significant and that the government actions affecting it require due process. This, combined with the fact that the legislature has 1, statutorily deemed police personnel files confidential, 2, declared internal police disciplinary investigations inadmissible in civil actions, and 3, expressly included right to know law exemptions from personal materials such as records related to internal personnel practices, personnel files, and directed public bodies to address personnel related issues in non-public sessions, certainly leads inescapably to the conclusion that officers have strong privacy rights in their personnel files because it is made up of their personal history and disciplinary information. We are certainly not looking to hide exculpatory information having to do with an officer's possible wrongdoing, bias, excessive use of force, etc., as that information should absolutely be attainable. We're merely looking to safeguard the personal information of officers. And I will submit the rest of my written testimony to the committee. And I would concur with the lady who just spoke before me that, yes, I think the work of the commission has been done. The final report has been posted. It's just that the governor then has kind of given his marching orders, and now the work of those to finish up on those recommendations has not been done, but the actual commission work has been completed.
Thank you very much. Thank you very much, Chief. Are there any questions from members of the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question, Chief. So you just testified about, this understandable interest about protecting really private information, but wouldn't you agree that the way that this bill is written now would prevent disclosure of police files, even when there is no dispute that the officer committed misconduct, correct?
I'm sorry, could you say that again? That there's no...
So that the way that the bill is written now prevents disclosure of the officer's file, even when there was no dispute that the officer committed misconduct, correct? So it prevents disclosure, even if everyone agrees that, the officer, lied or, that he was terminated. That even in those cases where there's confirmed misconduct, no one is disagreeing that the way that this bill is written now prevents even that disclosure, correct?
I guess I would defer to Senator Carson on that. What I'm looking at is we certainly, majority of the police departments across the state have policies in place where internal investigations are completed and then reports are done. And I know in particular here in Guilford, that is posted on our website. So that is public information. I do that at the end of every year. So that information that they're looking for is out there. So it's not the personnel file with all the public information, but it does list that information if there's been any internal investigations that have been done and whether those are sustained or not sustained, or any complaints made by the public.
Do you have another question, Senator?
Well, he deferred to you to sort of answer that question.
I don't even remember what the question was. Sorry, it's been a long afternoon.
Totally understand. So there's been a lot of conversation rightly about private information, right? Which we all, I think, agree there's no public interest in disclosure of really private information, right? But the question here is the way that the bill is written now, my reading is that it prevents disclosure of files even when there is no disagreement about misconduct. So misconduct like lying, termination, that the way the bill is written now, it prevents disclosure of that.
Thank you. I guess the question is for me. I believe that this bill, I guess, and I would agree that it's pretty broad, and I think you could interpret it that way. But I think it also goes back to the decision itself, that there needs to be clarity, there needs to be consensus. And so the bill is going to give us the opportunity to bring the parties together to see what we can figure out. So we can provide consistent guidance, because if you think about some of the testimony, and they talked about the balancing act and the court, is there a guarantee that each court is going to interpret that balancing act the same way? And I think if the legislature can look at this and put together the elements of what should and should not be included within that balancing act to provide guidance to the court, I think is going to provide a lot of that clarity that folks are looking for. So this is, in my opinion, a starting point for that conversation, rather than looking at it like, oh my God, this is exempting everything. Let's start and let's dig into this. We've gotten some conflicting information about the LEAC report. We had one person tell us that it's not finished. And other people have said, yes, it is finished. So I think those are things that we need to work through, and this legislation will give us the vehicle to do that. So that's the way that I view that. Did I answer your question?
You did, thank you.
You're welcome. Okay, are there any further questions for the chief? Okay, seeing none. Thank you, Chief. The chair is going to call John Krupski.
Senator, I do not see a John Krupski in the attendees column.
Okay, is there a Mark Bowden?
Yep.
Okay, why don't, I know that they're both attorneys that work together, so perhaps Mr. Bowden is here to in Mr. Krupski's place. So good afternoon, Mr. Bowden again.
Good afternoon. Yeah, no, I think he's supposed to be on here somewhere too, and I think he was going to speak about some other aspects of it. I'll try to speak to both aspects. I'll try to be as brief as I can on this. I think there's a little bit of confusion about what an actual police personnel file is and what's actually in there. I think there's a lot of assumption that there's a lot of secretive material in there, that the public would open this file up and go, oh, look what I found. There's really not a lot of that. So I'm going to talk about the three aspects in here that are in this bill. One of them is pre-employment background information. Pre-employment background information is just that. I applied to a position here with a police department, and I have this questionnaire that can be anywhere from 20 to 40 pages long that I have to fill out. It's going to have every place I lived. It's going to have all my financial information in there, every bank I had, credit card I had. It's going to ask me about past, significant others that I've had. It's going to ask about, any criminal activity I've been involved in, any drug activity I've been involved in, any motor vehicle history I have. I mean, it's pretty comprehensive. It's going through somebody's life with a fine-tooth comb. And the reason we have that is because you want to have a police officer that has been vetted thoroughly, so that you don't have any of these issues that a lot of the, unfortunately, a lot of these callers have talked about. You know, I apologize to them for the way they've been treated, that they shouldn't be treated that way. But that's why we do a very thorough background investigation. So there's a lot of sensitive information in there. And I agree with the Municipal Association when they say it's hard to figure out, okay, what can I release? What can I release? So it's easier for them to have a bright line rule. And I think that's what we're looking at here as to how can they respond to this. I don't think there's a lot of information in the pre-employment background that, quite frankly, is any of the public's business. This is very personal information to that individual. So that's one section of a file. The other section of the file I'll talk about is a regular personnel file. In that personnel file, you're going to have information such as my, you know, as we talked about, and I think everybody's in agreement, you know, addresses, blood type, you know, pay codes, all kinds of other, you know, things that you would typically find in an employment file. Again, nothing that's very exciting, nothing that I don't think anybody is looking for that I've heard from today. I think what everybody is talking about and everybody's concerned about is this other section that's called internal investigations. Now, internal investigations, I agree with what a lot of people have talked about. I think sustained findings of that involve discipline. I don't have an issue, and I don't think you'll hear any other police officers say they have an issue with that being released. That being said, these investigations are very thorough, and these investigations can include other police officers. They can include private citizens. They can include victims, witnesses. So there's a variety of other individuals that may be pulled into this investigation because of an accusation against a police officer. And as such, right now they enjoy some confidentiality. So they feel like they're free to be able to talk about what they experienced and what they saw. And what I mean by that is an internal investigation file isn't even released to the police officer once it's completed. The police officer can't even get a copy of that. The only time the police officer can get a copy of that is if it results in discipline and that officer decides to appeal. Then I, as their attorney representing them in a form of discovery, can get a copy of that file at that point. But prior to that, it's confidential. So even if they sustain a finding and say, hey, look, we're not going to quote unquote discipline you for this, but we're going to counsel you, which means we don't agree with what you did. We're telling you there's a different way to do it. This is how you should do it differently. The officer doesn't even get to see that, doesn't even get to see what other people said or what other evidence was involved in that particular case. So there is a lot of information in there, and this would have a chilling effect if these files were released. Now, that being said, we don't necessarily have an issue with, like I said, those sustained findings that result in discipline being released and an executive summary of that being released. And I believe that's what LEACT agreed to and came out with, was they didn't want to see the whole file go up because there is a lot of sensitive information in there. But they did feel that, yes, for transparency purposes, this information should be released, and an executive summary stating what had happened should be released as well too. Now, I think there's been some discussion about this bill, and this bill is looking to solve a problem that's been going on here since these recent court cases that have come out. And I applaud the discussion that's going on, that's gone back and forth here. But I think there is some room for some movement on this bill. I think some language could be slightly tweaked. I think you could add any public employee to it. And also the other thing I heard a lot of talk about too that I wanted to address was the EES. This has nothing to do with the EES.
Mr. Bowden, I'm sorry,
Sure.
you've gone over the 3-minute mark. So if you have some additional testimony that you'd like us to consider, please feel free to submit it to us. We're not going to be executing this bill today, so there's going to be plenty of opportunity for us to read it, and please include any contact information so that if any of the committee members have questions, they'll be able to contact you?
Sure. And I just
Okay.
forgot to introduce myself at the beginning. I'm Mark Bodwin. I'm a retired detective sergeant from the New Hampshire State Police. I am currently on the board of the New Hampshire Troopers Association, and that's who I'm representing. So, I mean, there is some, like I said, we want to be transparent. We want to work with the public, but we also want to protect our members at the same time. Thank you.
Thank you. I see Senator Khan has his hand raised, but before you ask your question, I'd like to apologize to everybody. My cat Ralph decided he wanted to see everybody today, so he just kind of did a drive-by.
That's just what we needed, Senator Carson. I apologize for that.
Cats and dogs, what can I say? Okay, it's all right, Senator Khan, the floor is yours.
Had he raised his paw. I have not seen an EES report, and I just would like to ask whether the Mr. Bowden or anybody else who's providing information to our clerk that that be included in that file. Thank you.
Thank you, Senator Khan. We are definitely going to get a copy of the LEAC report for the committee members to take a look at.
That okay, I have read that, contrary to popular view, or one person's view. But no, it is the I didn't see the EES report in that.
Oh, okay. Well, we'll get that as well. Okay. Thank you very much, Mr. Bowden.
Sure. Thank you very much.
I received a text message that Mr. Krupski would like to testify. So can we reach out to him?
So I'm thinking it must be under Jake. So I'm gonna allow Jake to talk. You're able to speak?
Yep. Can you hear me?
Yes. Is this Attorney Krupski?
Yes, this is.
Okay.
Good afternoon, Madam Chairperson. Good afternoon, members of the
Okay.
committee.
Just to interrupt you, Attorney Krupski, we have a 3-minute rule in effect, so the floor is yours.
Okay. Thank you very much, Madam Chairperson. My name is John Krupski. I have the pleasure of representing the New Hampshire Police Association as well as the New Hampshire Troopers Association and many law enforcement throughout the state of New Hampshire. And I, on behalf of the New Hampshire Police Association, support the Senate Bill 39. And I think that Mark previously had hit on a good point. Much of the testimony did not really address Senate Bill 39 and talked about other issues. And what I'd like to address directly to the board, to the commission, is what this bill is attempting to do, in my estimation. And this bill will make 3 aspects of a police officer's, and we are not opposed to including all public employees, files to be exempt under 91A. And that would be pre-employment inquiries, investigatory files, and personnel files. That doesn't mean that this information would not be available through other means. So it simply means that under a right to know, a person couldn't write a letter and say, I want the file of employee X, and automatically get it. What would happen is they would have to go through the other processes. I remind the committee, and I'm going to try to be quick here, that the New Hampshire Police Association did support 105-19, which passed, and that's a law now that went into effect in January 1st of 2021, in which we agreed to self-reporting misconduct and that the names of the individuals in a summary would be made public. So there is no attempt to hide anything. However, looking at the 3 areas, the pre-employment inquiries, that is covered under POL 301.05, and we can provide this later. But that is your financial information for 10 years, your history for 10 years, your information that you provide to your employers, everyone that you lived with, the name of your family, where you went to school, etc. All personal information done pursuant to Rule 301.05. You can look at that. There's no reason that that ever needs to be released, and we think that it should be categorically exempt. Number two is the investigatory files. As Mark had raised, the investigatory files, there's other ways that there's disclosure. The investigatory files currently is not released even to the employee if there's no finding or sustained finding. It is only released if that employee then files an appeal. It then, at that point, becomes, to the extent that it's utilized in a hearing, it becomes public record. So this information is not hidden. It just doesn't allow for, shall we say, that individual's personal recognition and their privacy to be invaded. It also allows them not to have a stigma. There was someone who testified that says, well, if they were charged 25 times with something, they must be guilty. Well, that's exactly what we're trying to keep people from doing, is taking a police officer who has complaints against them that are unfounded and then say, well, where there's fire, where there's flame, there must be fire. Where there's smoke, there must be fire. So it's simply a matter of, there are other ways to address it through other aspects. Now, as to the personnel files, I do want to make sure that I'm clear on this. They should be exempt and are exempt for all public employees. But what we have here is a problem. And because there's not clarity in the law, people have talked about these 3 court cases, but this is the truth of the matter. The truth of the matter is those court cases talk about internal personnel practices, not necessarily about personnel files, okay? There's a distinction there, and it's a big distinction. Personnel files deal with individuals, persons, and with their personal information. Now, under the EES decision that came out, that decision said that the EES is not part of a personnel file, okay? And the court said RSA 105.13b is a confidentiality file for police officers. However, now you have a conflict. 105.13b says police officers' files are confidential. Some people are reading the Seacoast decision to say, no, it's not an exclusion from 91A, but that's what it was always meant to be. That's what it always has been for the last 30 years. So when you read that decision and you take a look at that decision, what the court has said is specifically, we will not rule on 105.13b, but we will assume for purposes of our discussion of the EES that the personnel files are confidential and exempt from 91A. So all this law is trying to do is codify what's already been taken for consideration. Now, that doesn't mean there wouldn't be transparency, because there are other methodologies that people can get that information, whether it's through, public hearings, et cetera, or through requests in other avenues. It simply means that it wouldn't be available through 91A, and it would provide clarity in regards to the tying together the different laws, which right now doesn't have any clarity. The other thing,
Mr. Krupski, I'm sorry, I'm going to have to interrupt you. You've gone over your 3 minutes.
I'm sorry, Senator. I was trying to go as quick as I could.
I know this is a complicated issue, and I know that there's a lot of things that people would like to talk about. What I'd like to do is suggest the same thing that I suggested to Mr. Bowden, is that you write something up for us, and please provide your contact information. And that way, when the senators have the opportunity to read your written testimony, they'll be able to contact you with any questions they might have.
Absolutely, Senator.
Thank you. Thank you very much. Senator Whitley has hopefully a quick question.
I don't know if it's a quick question, but just sort of wanting to dig in deep more about attorney, I'm sorry, I don't remember his last name. The attorney's,
Attorney Krupski.
Krupski, excuse me, Attorney Krupski's statement about how internal investigation files are available through other means. And so it would be helpful to explore how those other means, particularly for those cases. Say, an officer is, has, multiple incidents of misconduct and they're not appealed. There's no hearing or anything. So can you walk through those instances where would be otherwise available?
Sure. I guess currently right now we're working on a consensus. I think this was one of the things that the LEAC Commission has done, and they've issued their report. And there is a group of individuals who are working to try to create legislation to fulfill the LEAC recommendations. And I think that's what you heard from Julian when he had testified, is there is a group trying to reach consensus so that there is transparency while protecting the reputation of police officers. And that we're working on that right now.
Okay. Do you have a follow-up, Senator?
Well, it didn't quite answer my question. He had indicated that there are other ways that are available now to get the information we're talking about. And I want to know more about what those were.
Sure.
Particularly in those cases where there wasn't a public hearing.
Okay, and then there's also, if I might, Senator, there is under the police standards and training, there is a thing called a Form A. If someone is disciplined, even up to 1 day of suspension, they have to report that to police standards and training. Police standards and training then has the obligation to review that and will hold a hearing in regards to, that individual's, whether or not they should maintain their certification. So that automatically happens when anyone is disciplined under the system.
Okay, do you have a follow-up, Senator?
No, I still don't feel like we sort of walk through those situations. So if he could send some follow-up in writing, that'd be helpful.
Thank you very much.
Thank you. Senator Khan?
Thank you. So Form A is a new term in the hearing. Is that something that's accessible?
Yeah, the if I might, Senator, I don't know if the Form A itself is accessible, but I know that the information, once they receive that information, if they take action on a certification, that becomes a public hearing. I mean, I don't want to jump into the other bill, and I know everyone had a tired weekend, but that's governed by 91A, and under 91A, as you know, all hearings are public, and unless they fall under an exemption under 91A3, in which they have a non-public hearing. So that the commission would vote on whether or not it's public or not public, and then there's a procedure that you follow thereafter.
Okay. Okay. Are there any further questions?
Not a question. I think
seeing none. Thank you. Thank you very much for your testimony this afternoon, Attorney Krupski.
Thank you very much.
The chair is going to call Ms. Alhouni.
Thank you, Senators. So again, my name is Ms. Alhouni, and I'm with RAD New Hampshire. I, again, will try to make this as short as possible. I am speaking against this bill, and to remind people it's vital that we're respecting leaders like Black Lives Matter Manchester, who were here earlier, and other experts as well. So as I mentioned earlier in my testimony, officers should be held to a higher standard of accountability because of the power they hold within our communities. So it's very worrisome that there's an attempt to protect officers further, an institution already protected. And it's well known that police get shielded time and time again. So this is making no sense to me. So again, this is disturbing. It is not okay that police with bad pasts get to continue to practice in our communities. That should be disturbing to all of us because we decided to protect their past, right? This is a dangerous message, but more dangerous is the practice of actually making this happen. So we need to move away from protecting corrupt officers. So this bill is a way, this bill, in my opinion, is way more harmful, and Rights and Democracy's opinion, this bill is way more harmful than any of the interpreted good that was mentioned today and sets us back as a community, right? So it's no surprise some police officers are going to oppose this. It's in their benefit to protect themselves, but especially it's in the benefit when they do corrupt practices, right? And I'm not saying that all police officers are doing corrupt practices, but I'm saying that of course they want to protect themselves. So we can't prioritize the wishes of officers to further protect themselves with more immunity, which they already have enough as it is, against the accountability that's desperately needed. So we need to oppose this bill in every way possible.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none. Thank you very much for your testimony.
Thank you.
The chair will call Jasmine Dolb.
I don't see anyone with that name in the attendees column.
J-A-S-Y, with Jasmine with a Y?
No.
Okay. Next, we will go to Scott Trout.
Hello.
Hello. Good afternoon, Mr. Trout. Thank you for hanging in there. It's been a long afternoon. I'm just going to ask you and inform you that we have 3 minutes for everyone testifying, and please do not repeat testimony we've already heard.
It'll be pretty difficult for me to repeat the testimony. My name is Scott Trout. I'm calling from Stratford, Vermont. Thank you guys for having me here.
Thank you. Please continue.
Okay, I've had kind of a delay here, but anyways, I am currently before the New Hampshire Supreme Court, and I'm expecting the ruling in the next month. Keep having a weird reverb here.
Would you prefer, Mr. Trout, to perhaps submit written testimony instead?
Now, hang on. Can you hang on 1 second? Let me see if I can finish this.
Okay.
Can you hear me now?
Yes, we can hear you.
Okay. I'm sorry for that technical
That's
difficulties.
okay.
I only had, so anyways, yeah, I'm a Vermont resident. I'm opposed to this bill. I am kind of the poster child for what goes wrong in the system when police files are hidden from the public and from criminal defendants. Currently before the New Hampshire Supreme Court after 13 years of fighting unsuccessfully to get access to police criminal files and police disciplinary files.
Mr. Trout,
to
we
my
lost
trial,
you.
the prosecutor was asked. Oh,
We keep
hang on a
losing
second.
you.
Mr. Trout, I don't know if it would be easier for
Oh
you
boy.
to jump off and then call in via phone. There's a call in by
I guess
phone
I could.
option. If you want to do that, we'll move on to somebody else and you can jump off via Zoom and call in and raise your hand.
Sure.
Okay, why don't we try that? Okay.
Thank you, ma'am.
Look forward to speak with you. Okay, let's go to Tristan McLean.
I don't have a Tristan McLean.
Okay. Let's go to Jerome Trudeau.
I also do not see a Jerome Trudeau.
Okay, yikes, my iPad is gonna die. Is there a Mark Morrison?
Yes.
Okay, why don't we go to Mr. Morrison? And I'm gonna just hand the gavel to Senator Gannon because I've got to go get my charger.
Thank you, Senator Carson. Mr. Morrison, welcome.
Good afternoon, Senator. Thank you very much. I know it's been a long day. I will do my best to be brief and try not to repeat. My name is Mark Morrison, and I am testifying today in favor of this legislation on behalf of the New Hampshire Police Association. I've been in law enforcement for almost 22 years, and I'm currently a lieutenant with the Londonderry Police Department assigned to professional standards and accreditation. I'm the current president of the New Hampshire Police Association, and it is through this role that I've had the privilege of participating in various meetings, work groups, and I also served on the LEAC Commission. I can speak quite a bit about, how I think New Hampshire law enforcement performs. And I think Attorney Vogelman echoed my sentiments prior to me. We do a lot of hard work in this state to be as good as we can. What I'd like to do, I think, is clarify a couple of the LEAC sort of talking points that were brought up earlier. I do not believe that this legislation is in conflict with the LEAC recommendation, and I'll explain to you why. One of our recommendations was to support the formation of an entity. It was a proposal from the Attorney General's office, but that creation had some caveats to it. One of those caveats was the report and the hearing would be confidential. What would be released would be, the name of the officer and the executive summary. And we had a great deal of testimony, some of which I even provided, about why and why that's important to protect the integrity of these investigations and not allow, the in-depth details of these investigations that really do not need to be disclosed, to be released to the general public. And I think what you would find is exactly a chilling effect that has been mentioned before. You would have people that would not want to bring a complaint forward, would not want to cooperate for fear of just the public notoriety. But that should not stop an investigation. And the balance there is the investigation being kept confidential, but the findings being released. And that was sort of the balance that we struck on the LEAC Commission for satisfying what we obviously believe is a legitimate and reasonable and constitutional right of the public to know who they have in their police force. We're not opposed to that, but how you get there is where we choose to have our discussion. So for that recommendation, I believe, sort of to clarify, I think that would be in line with this bill. And the EES legislation solution was actually our recommendation. This exculpatory evidence schedule list had been, so mismanaged from the go. We really were looking for a solution in the name of transparency, cooperation. It was actually our recommendation, the New Hampshire Police Association, that put the recommendation forward to give everybody who's on the list notice, allow them a period of time to have a hearing in Superior Court to get off, and then at the end of that, publish the list. And that is not publishing personnel files. This was an attorney work product list that really shouldn't have been started back years ago. And it was our recommendation as a way out, to sort of help with this transparency. So in New Hampshire, I truly believe and subscribe to, the cooperation with our communities, and especially those who are even most critical of us. We always try to put our best foot forward, and we really look to, to be good community partners in New Hampshire. And I think that's why, you see surveys where we have an 85%, professional rating from our citizens. We try very hard. Are there times where people fail or people, make mistakes? Of course. And you will find that in any profession, in any state, in any country. We are no different. But our effort is there, and we really try to shape how we do this business here in New Hampshire in the best way possible. With that, I will stop talking and be happy to take any of your questions.
Thank you very much, Mr. Morrison. Senator Whitley has a question.
Thank you, Madam Chair, and thank you for your testimony. So I'm just, we heard some sort of conflicting information about the LEAC Commission. And so it's your testimony that this bill is consistent with the LEAC Commission, is that correct?
That's correct. And the reason, again, is because, you know, the information in the file was voted to be protected, but the result of the investigation or hearing is what would be released with that executive summary. And that, I believe, is really the best sort of, you know, balance to make sure the investigation is protected, the integrity of the investigation and the witnesses and you know, the sort of nitty-gritty details that really don't need to be, you know, displayed. But what really is at heart of this investigation is the result. You know, what happened? What was the finding? That was really the balance, you know, that we struck in our hearings, and that's what the recommendation was.
Follow up?
Yes, follow up.
Thanks for that. So if you could send the committee that specific recommendation about the executive summary consensus that you all reached, that would be helpful. But the bill as written does not say anything about it. It precludes disclosure of the whole kit and caboodle. It doesn't say anything about the executive summary. So what you're discussing, that's not in the bill yet, correct?
No, but I think this would circle back to what Attorney Krupski had mentioned before, where there are other avenues, you know, to get the same information without, you know, releasing the file and while protecting the integrity of the file. You know, this is certainly, you know, the first step, I think, in really getting, you know, to the bottom of where I think we need to be as far as the, you know, transparency and conveying of information.
Okay. Are you all set, Senator?
Yes, thank you, Madam Chair.
Okay, Senator Khan, did I see your hand up?
Madam Chair, I wanted to ask Mr. Morrison one question.
Sure.
He is a member of LEAC, and it's come up a couple of times. Is LEAC continuing to meet? Will it meet in light of some other decisions, or has it completed its recommendation work?
I think the best way to answer that, sir, is there are no more meetings scheduled for the LEAC Commission, certainly that I'm aware of. And I think the best way to describe the work the LEAC did is how it was described earlier, that the recommendations that we had were submitted and are now being acted on by the appropriate people or institutions. Some of our recommendations, you know, could have were taken care of through executive order, some were policy, some were legislative in nature. So that is, you know, the recommendations have been presented.
Are you all set, Senator?
I am. Thank you.
And so I hope
Thank
that
you.
answers your question.
Thank you. Are there any further questions for Mr. Morrison?
Just one for.
Yes, Senator Whitley?
So I was curious whether you had discussed this bill with other members of the LEAC Commission since it was introduced.
No, I have not discussed this bill with the other members of the LEAC Commission. You know, we're not meeting in any sort of formal way because the commission is essentially submitted their recommendation.
Okay. Senator French, did you have a question? Senator French?
No, I was pointing towards my candy bar and giving instructions for it to be passed to me under the table. Thank you.
Okay, I just wanted to make sure. Have we heard, has Mr. Trout called in?
I believe he has. We have two phone numbers, Senator. And I believe one is Mr. Brooks, who we spoke to earlier on a previous bill. And I think the other one would be Mr. Trout. We also have Mark Broth and Wanda Dorea with their hands up as well.
Okay. The list just keeps going. And it's.
Wanda has just put her hand down. So we're down to two phone numbers and Mr. Broth as well.
Okay. Mr. who?
Mark Broth. I believe he is on your list under being listed as neutral on the bill, but speaking.
Okay. Okay. Why don't we go to Mr. Trout first?
So Margaret, I think he's the second number.
Okay.
Hello again, folks.
Hi, Mr. Trout. That's so much better.
Yeah, thank you.
I would just like to remind you about the 3 minutes and
Yes, ma'am.
Please get started.
Okay. I did a year in prison in 2009 after being convicted in a trial that ended October 22nd, 2008 in Grafton. During the course of the trial, Grafton County attorneys never disclosed the disciplinary histories of the law enforcement officers that were testifying against me. In fact, arrested me and charged me. Turns out that this bill, which I'm in opposition to, would continue the process of shielding law enforcement officers who have committed misconduct from the consequences of their conduct. And I would be remiss not to remind you guys, I am currently in the Supreme Court. I have an appeal that's going to be decided probably the next month or two. It was heard on October 22nd of 2020. And basically, let me explain why the disciplinary records issue is important, not just for the public, but for criminal defendants. There was no evidence, and I'll just take you for a walk during the course of my trial. There's no physical evidence of an assault on any of the police officers I supposedly assaulted. In fact, I was only found guilty of simple assault on one of them. There was no marks, no bruises, nothing. So it became a he said, she said. The prosecutor in Grafton County knew and relied on the fact that police officers' disciplinary files in New Hampshire are completely devoid of disclosure until the recent Seacoast and Union decisions. So she told the jury, and she knew this was wrong. We discovered it after the trial, years after the trial had gone by. We discovered that when she told the jury, there was no hint of misconduct whatsoever on either police officers' files, that they had led stellar careers as police officers. They are experts and professionals. In fact, there wasn't even a hint of misconduct. We discovered later that one of the officers had been sued in federal court for police brutality, putting a gun to a person's head, and the other officer, and this is in Lebanon, New Hampshire, was suspended for 2 weeks for consequences from an extramarital affair and threatening a witness and other misconduct. And he has now been suspended for 8 months starting last May on a separate issue. What's interesting here, let me remind the committee about this. Like I said, I'm still in the Supreme Court. Hopefully we'll get a decision which will enhance the union leader decision, the Seacoast leader, in terms of how it affects criminal defendants, is that the prosecutor could rely on a lie to the jury to get a conviction, knowing there was no way without some kind of intervention, some stroke of good luck, that I'd actually discovered that they had the files, that they had this disciplinary record. So she lied to the jury. So that's why, to me, my mind's eye, it's important that people get these files out and get them in the public, because it's allowed the prosecutors the latitude to lie. Now, in other incidences, which I've discovered in misconduct here in the Upper Valley, New Hampshire and Vermont, the main feature of everything in a prosecution seems to be that the cops can get up there and they can testify and not be afraid of the consequences of prior bad acts. And that's what leads to the convictions. And it's led to a lot of people having absolutely zero faith in the system. So if 39 passes and becomes law, I agree with one of the earlier folks saying it is a step backward. But what I would also ask you guys to take a look at is, given all the sum total of what's going on in the last year and what's the public's clamoring for transparency and openness, it stands to reason that when you look at a guy like me who does a year in prison with no physical evidence of an assault, I lost a year of my life, I lost my security clearance, and it's now 13 years later, I'm finally in front of the Supreme Court with the Supreme saying, yeah, we have to make a decision. Is it okay for a prosecutor to lie repeatedly to a jury? And is it also okay for that prosecutor not to disclose the disciplinary histories? The cost of the state of New Hampshire to incarcerate me had to be about $50,000 for the year, plus all the appeals I filed and the motions for new trials. I mean, the costs are exceptional. So what I would say is this is an interesting way, if we can get away from 39 and have more transparency in government, you're going to look at a much more efficient government. You're going to look at prosecutions that are more likely to stand the test of time because we don't have this type of officers testifying and then appeals coming back to basically haunt all the departments and agencies. It's going to allow, if 39 is not permitted to pass, it'll have what I think is an effect to send a clear statement that you got to clean up your shops. You got to clean up your departments, the state cops, the local cops. You can't have bad apples and you can't tolerate them within your ranks. I would also be remiss to say I would not be where I am without having had good police officers provide information on my situation. So it's not like I'm out here bashing all the cops. They do have a hell of a job and they have a very difficult and dangerous job. I don't deny that. But I've seen the bad side, as they say. And what I would ask you guys to do is to vote down 39 and get on with the business of having more full transparency within the police departments, clean them up a little bit. And that's all I got for now, guys. I appreciate you listening to me.
Thank you very much for your testimony, Mr. Trout. Are there any questions from the committee? Seeing none. Again, thank you very much for your testimony.
Thank you.
Okay, Mark Bra, I don't see him on the list of people, but I think Jen, you said that that he was okay. Let's get him, and then we'll do the last one of the call-in.
Thank you, Madam Chair and members of the committee. My name is Mark Broth. I am a lawyer with the Drummond Woodson Law Firm. I've been practicing labor and employment law in New Hampshire for 38 years. And most of that time I have been representing New Hampshire towns, cities, counties, and school districts on labor and employment law matters. I have been involved in innumerable public employee disciplinary cases, terminations, and am very familiar with employee personnel records. I wanted to address a question that Senator Khan had raised with earlier today. And Senator, I apologize if I paraphrase incorrectly, but the question essentially was, why is legislation necessary? And the answer is that the court system is a very inefficient way to draft legislation. And it's an expensive way, and it's a time-consuming way. The state of the law as left by the court as a result of the decisions in the Union Leader case last year is this balancing test, a test that the towns and cities and school districts have not had to apply in the context of personnel records for the last 27 years because of the Fenneman decision. So they are now dealing with these cases really with a blank slate, and the court's prior guidance on balancing tests is of very little use when applying it to the personnel record area. 91A is a creature of the legislature. The legislature decided that to implement a right to know law and created exemptions to it. The court has essentially interceded now twice in the legislative process, once by interpreting 91A5 as creating a total blanket exemption for personnel records in the Fenneman case 27 years ago, and now coming back and saying we were wrong in Fenneman, it's a balancing test. The issue really is it's for the legislature to decide what is and what is not for the public to see and not for the courts. As someone who has represented towns and cities in prosecuting employee discipline cases over the years, I think it is important that the public have access to information regarding founded misconduct on the part, not just of police officers, but of any public employees. I also think that not just police officers, but any public employee has a right to be protected from the disclosure of unfounded, unsustained allegations that are made against them. I just throw out the name for those who remember it of Richard Jewell, if people remember at all, Richard Jewell was a guy who was initially accused of being the Atlanta Olympic bomber. And he went to his grave some years ago with people remembering him for doing something that he didn't actually do. He wasn't the Atlanta bomber, but you couldn't get rid of the stigma that was associated with the accusation that had been made against him that he had engaged in this conduct. And I think in fairness to public employees, both police and in other jobs who do their job every day, the publication of information regarding an allegation made against them that is unfounded or unsustained can be a career killer in the age of social media. So I think it's important that this committee look at legislation that draws some bright lines for the towns and cities and school districts to follow in figuring out what should or what should not be made public, rather than leave it for courts to make decisions and then over a period of years for these cases to go back to the Supreme Court, and we build the bright lines over time as to what how the balancing test should really be applied. This committee really does have an opportunity to draw those lines, to say that yes, the public has a right to know about founded misconduct by any public employee, but no, the public really doesn't have an interest in knowing about scurrilous allegations that can be made against public employees at time. The disclosure of those allegations could be ruinous to their careers, to their families, to their marriages. I think there's really a need to draw a bright line there rather than wait for the courts to eventually draw that line for us.
Okay, thank you very much for your testimony, Attorney Broth. We have a number of senators who have their hands up. Senator French has a question.
Yeah, thank you, Madam Chair, and thank you, Mr. Broth, for your testimony today. I find it interesting, your concern for the officers having made public unfounded allegations, when isn't that the case when every individual is arrested and it's posted in the paper prior to trial, and the fact that they were arrested is always made public? What's the difference there?
I don't pretend to be an expert in constitutional law and why. I agree with you. There are concerns about fairness to those people who are arrested. But in the context of public employees, what is the benefit to the public of hearing about allegations of misconduct that after investigation and in many cases adjudication in front of labor arbitrators, it has been determined that they did nothing wrong, or there's insufficient evidence to establish that they did something wrong? What is the public gain from learning about that versus the damage to those people's reputation? These are our employees as taxpayers. These are our employees as town and city and county municipal officials. Having their reputations destroyed in the public arena serves no good purpose.
Okay, are you all set? Senator Khan, I believe you had your hand up.
I did, Madam Chair, and thank you. Thank you, Mr. Broth, for your testimony. I wanted to ask you that it's been pointed several other presenters that we're talking about three different aspects of records: personnel files, internal investigations, and pre-employment background. And it seems that, to me, that in 91A5, two of those three are pretty clearly dealt with. And I guess I'd like to establish that maybe you and I agree that the personnel files and pre-employment background information that's contained in personnel files, that information is pretty well covered in 91A5.
Senator, I can't agree with that, because the the language in 91A5 speaks to the non-disclosure of personnel records. And personnel records was understood by the court in the Fenneman case as applying to basically any piece of paper that had the employee's name on it. It was broadly interpreted in that sense. The court's recent decision last year now views personnel records as only referring to internal policies adopted by public employers, many of which public employers put on their website. So there's no confidentiality interest in those things anyway. But it is the personnel files, the investigative files, labor arbitrator decisions with regard to allegations made against public employees. Those are all the records that are at issue now, where there is, on the part of certainly the media and civil rights organizations, understandably, a desire to see anything and everything. But on the other hand, there is this competing desire on the part of individuals who have chosen to work for the public to retain some level of protection of their privacy and their dignity by not having scurrilous accusations which could be made against them, unfounded accusations that could be made against them, made public and have their lives destroyed simply because they chose to work in the public sector as opposed to the private sector where none of this would be occurring.
A follow-up?
Thank you. And pre-employment background investigations, I'm sorry, pre-employment background, is that adequately covered?
So I think that's a little bit more unclear. There's only one definition of what is a personnel file in New Hampshire law, and that's under the Department of Labor statute and regulations. And pre-employment investigation materials is generally not considered personnel records, but the way the court has left it as a result of these recent decisions, it's unclear as to whether a town or city could decline to disclose pre-hire information and not face a lawsuit from an organization for under 91A for failing to disclose it, and then facing a lawsuit from an employee for having disclosed it. So there really is, I think, a need for the legislature to fix and make clear its intentions with regard to 91A, rather than have the court decide those things for you, which is where we are today.
Thank you, Madam Chair. Thank you.
Senator Whitley?
Thank you, Madam Chair, and thank you, Attorney Broth. Full disclosure, Attorney Broth is a colleague of my husband in the same law firm. So my question, Attorney Broth, is, understand, I really do hear what you're saying about, ruining the reputation of a public employee. And that's a real concern, and I share it. I think the conversation here is this balance of also making sure that the public is aware of, even when, misconduct was not found, even, ensuring that the public has transparency and ensuring that the process, the actual investigation, the integrity of the investigation is solid. And so how do we deal with that? How do we ensure public trust, particularly when we're talking about, making sure that we are moving towards transparency to build trust with the public, with police officers. So particularly in the case of police officers, how are we going to ensure that the public has the ability to vet the accuracy and integrity of the investigation if it's not released?
2 quick points. If it was disclosed tomorrow that Senator Whitley does not beat her dog, I would submit to you that's not helpful to Senator Whitley's reputation. And I'd also suggest that for most public employees, I think 80% of the public employees in New Hampshire are represented by labor organizations. They have collective bargaining agreements that provide for binding arbitration. their disciplinary cases are heard by third-party neutral arbitrators who make the decision ultimately as to whether or not there was sufficient evidence to establish misconduct or not. If the findings of misconduct are made, then I'm all in favor of disclosing those portions of the arbitrator's award that explain what the officer or other public employee did wrong. But if the arbitrator were to decide that some accusation against an individual were not founded, again, I don't see how the public's interest is served by finding out what the person did not do wrong. The damage to the individual's reputation seems to outweigh the public interest in that regard. And isn't it better for the legislature to draw those bright lines than to let an infinite number of court cases over time try to sort that out for you?
Do you have a follow-up, Senator?
Well, I'm sort of formulating the follow-up. You know, it's, again, you know, we're balancing the interest of public transparency and the integrity of the investigation versus the individual's right to not have their life ruined, right? And so, you know, in each of these cases, they are very, very fact specific. And so I'm struggling with the legislature being able to, you know, put all these bright lines in place when these situations are so fact dependent. And so just as Attorney Broth identified, you know, there are these interests that are competing with each other all the time, and they're very valid interests. And so it does seem to me, you know, that, you know, this conversation is very important about whether it is appropriate for the legislature to put all these bright lines in place when it's so fact specific. I'm sorry, there's not a question in there, but.
If I could just respond, Senator, but the situation we're in now is these cases are starting to appear in the Superior Court system. And we will have some Superior Court judges who, well, the judges will span the spectrum of the testimony you heard today. There will be some judges who say the public should see everything, and there will be others who will have much more restrictive views than that. Those cases will ultimately wind their way up to the Supreme Court, and in a very piecemeal basis over who knows what period of time, the court will establish guidance as to how this balancing test is supposed to apply. Meanwhile, as Mr. Johnson from the NHMA said earlier today, towns and cities and school districts and counties are dealing with this every day. Those requests come in every day. And every time they make a decision about what to disclose and what not to disclose, they're often doing it in the context of both parties, those seeking the information and those seeking to oppose its disclosure, threatening lawsuits over whether they disclose or not disclose. So there is a real opportunity here for the legislature to say what it meant when it created the exemption in 91A5, not for the court to say what the legislature meant, and for the legislature to help the towns and cities follow the principles of 91A, be transparent about how government works, but to show the towns and cities, this is where you can fairly draw the line between the interests of the public and the interest of our employees as taxpayers who are doing the right thing and shouldn't be damaged where they've done nothing wrong, or what's been determined that they've done nothing wrong.
Thanks for that follow-up.
Okay, are there any further questions from the committee? Okay, seeing none. Thank you very much, Mr. Broth. Please make sure to provide us with contact information so that if any of the committee members would like to follow up with you, they're able to do so.
Certainly, Senator, and I hate to be the last thing between you folks and dinner, so thank you for your patience and time.
Oh no, that's okay. We've got more work to do.
Okay.
So thank you very much for testifying.
You're welcome.
We have one last person who's on the phone. Do you know who it is? No?
No.
Okay, let's put them through. They're the last ones. Hello?
Hello.
Hi, could you please identify yourself for the record?
Yeah, my name's Joseph Brooks. I'm born and raised in New Hampshire. I have a lot to talk about, so I'll try and get it all in the 3-minute timeline. And I also know that there's a lot that's been covered, so I should be pretty good on topic covering.
All right, terrific. So why don't we go ahead and get started?
So I am definitely in opposition of this bill because in the summer of 2019, I was accosted by police at a barracks trying to follow New Hampshire state law and have my travel permit signed and verified that I was on my way out of the state for the second time at the barracks when I was stolen from by the officer, harassed, lied to, and then elbowed in the chest on video camera, kidnapped out of the side of a vehicle, beaten and slammed into the ground for asking a cop a question on video recording. And I now worry that IA, who has deemed that the officer has done nothing wrong after I signed a Queen for a Day in New York, you know, there needs to be transparency. Laws like this need to go away and not come into place. The evidence exculpatory list needs to become public because 7 days a week, I, as a United States registrant, am not subject to that same privacy. And when I called officers into my home to protect me when my home and my vehicle were being vandalized and threatened, the officers said to me and my family, other people feel differently. What's going to protect me now? I cannot trust my police. I cannot call my police. The last time I had police called to my home, I called them because the neighbor was in my driveway threatening me with a gun, telling me when I called the cops that he was going to shoot my family. Well, guess what? When the cops got here, they attempted to file charges with the Dover prosecutors against me and then didn't bother to say anything to me. I found out about it on an audio recorded call with the Dover prosecutor. So, this is how protection is represented in New Hampshire in a live free or die state. Slaves are made in such ways. Benjamin Franklin once said, when a long train of abuses and usurpations pursuing invariably the same object evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and provide new guards for their future. I don't believe in throwing off government, but I'm going to tell you, I don't have police that I can trust anymore. I don't have cops that I can call and have represent me, and I am run off the road 7 days a week, harassed, and not represented appropriately in legal affairs. This is not how government was meant to work. I came out of prison and I'm still on parole, fighting to stay for my freedom, that every time they run my tags, I'm going to be reported as somebody who assaulted a cop who refuses to sign the charges. Okay? And I have to deal with that with every cop that pulls me over and thinks I'm a threat in their world. I've never raised a hand to a cop. I've lived and been raised around law enforcement families and communities my whole life. And you know what? I made a mistake a long time ago, and I manned up like a man and faced it. Walked in and said, I did this. Took 20 years. That's one mistake. I'll never live down, and I don't begrudge the time. I did it, and I'm doing it. But you cannot rip a person from a vehicle and beat them on the ground for asking, what is your probable cause, sir? That is not the way communication and transparency in public justice is done. This is why you will not have citizens trust you anymore if you refuse to ban this law and make the exculpatory evidence list legal and public to the world. Please and thank you.
Thank you very much, Mr. Brooks, for your testimony. Are there any questions from the committee? Okay. Seeing none, thank you very much, Mr. Brooks. It was a long public hearing, and thank you for waiting. Okay, I am going to go ahead and close the public hearing on Senate Bill 39. We have one bill left. Would the committee like to take a 5-minute break, or would you just like to power on through? I don't think this next one is going to take very long.
Go right ahead, push it.
Okay, is everyone else okay with that? Okay, is Senator D ready to go? Does anybody know that? Yeah, he's here. Okay, I'm going to go ahead and open the public hearing on CACR 12 and recognize the prime sponsor, Senator D'Alessandro. And I think you deserve the award today, Senator, for waiting. We really appreciate that, but we also apologize for running behind. Is he, I see, he's muted. Senator D'Alessandro, can you unmute? We can't hear you.
I think I'm all set now.
All right, we are. Oh, good to hear your voice, Senator.
Thank you. Well, listen, I commend each and every one of you for your patience and perseverance. I've listened to most of the hearing, and indeed, it's been a long and tough day. So kudos to each and every one of you for your patience and listening techniques. I come before you as the prime sponsor of CACR 12, an act relating to the retirement age for judges. When our Constitution was created, the average life expectancy was around 50 years. Average life expectancy now is almost 80 or beyond, and beyond 80. Through the course of my time in government, I've seen some wonderful judges have to leave at age 70. And as a result of that, voids were created where we had to go out and find new judges and bring them up to speed and so forth and so on. And it seems to me the one thing we're losing is the great experience, the insight, and the judicial temperament that goes along with being a member of the court for an extended period of time. We've also had situations where judges get appointed later in life, and as a result, the time on the bench is quite limited. So I think the situation that presents itself now is, why should we have to retire at a certain age when that's been thrown out nationally? You know, the retirement age has been thrown out nationally. And why can't we let people stay on as long as they're willing to do it and capable of doing it? It just seems to me to make a great deal of sense. I know that we've had two Chief Justices retire because of age in my lifetime, and one of them is now a member of the House of Representatives, and I'm sure that I think he has a companion piece of legislation to deal with this. And you guys have been very patient. You've been around all day long working very diligently on pieces of legislation. I think this is a rather straightforward piece of legislation, and as a result, I won't spend a great deal of time going over it. My premise, I think, is consistent with what's happening nationwide as it relates to retirement age, and many people can function very, very well as they move along in life, and they bring the wisdom of the age, and in most instances are willing to serve as long as they can. And it's for that reason that I bring this piece of legislation forward. I hope you'll give it a very good look, a very hard look, and I just appreciate your patience. And again, kudos for the due diligence that you've manifested in a long day's work. You earned your $100 today. I'll tell you that. And then some. And I will buy Senator French a candy bar. I'll buy him a whole flock of candy bars. He deserves them.
Thank you, sir.
Favorite, Senator. No, wait a minute, Senator. You're gonna spoil him. Don't.
Well, I know he shares with everyone because he's a great American.
Yes, he does. He's great. Thank you, Senator, for again your patience in waiting this afternoon. And I think Senator French has a question for you.
I do, for the good senator. Is it true, sir, that at your age now you look at any group of 70-year-olds as just a bunch of kids?
I treat them like children, Frenchie.
I thought so. Thank you, sir.
You're welcome.
Senator Khan, you have a question?
Thank you, Madam Chair. Good afternoon, Senator D.
Good afternoon.
In your testimony, you mentioned Supreme Court justices who retired at the mandatory age.
Yes.
Circuit court judges who have left the bench at comparable ages. I just wanted to establish that the intent of the legislation is to cover all New Hampshire judges.
Yes, yeah, that's for sure. Thank you for that clarification. If people didn't, I think people got that, but if they didn't, that's a very good point. And And indeed, that's correct.
Thank you. Senator Whitley, do you have a question?
I do. Thank you, Madam Chair. And hello, Senator D. Thanks for joining us on our 5-hour hearing, 4-hour hearing.
Yes.
Yep. So I'm just curious, actually, what other states have been doing with the age of judges. Is this a unique New Hampshire situation, or is this something that other states are having to deal with as well?
Let's just say I don't have a really good answer to that because I haven't done a great deal of work, but we're much different than many other states. You know, in most states, in many states, they elect judges. They campaign, and there is no retirement age. They just keep going. We appoint judges, and we have the mandatory retirement age. I don't know how many states follow that same protocol. As I said, one of the things that I like about New Hampshire is that we do appoint judges, and they're not out there campaigning as they are in other states, and that's been brought to my attention by my colleagues, legislators around the country. The amount of money a campaign for a judge spends, and it's inconceivable to me. So. But I don't know. I don't have an answer, but I'll get it for you, Rebecca Whitley. I will get it for you, and I'll make it a point of law. How's that?
Thank you, Senator D. Appreciate it.
You're welcome.
Are there any further questions from the committee?
I should know better.
Senator
but I'm gonna
Gannon?
ask a couple more. Hi, Lou. How you doing?
Good, fine, Senator.
Good to
How are
talk
you?
to Senator. As far as I know, there's no shortage of young attorneys. There's tens of thousands of us in New Hampshire, right, who are going through the system.
Yes.
Is there a shortage of judges out there that I'm unaware of, or applicants?
You know, I don't know how many have applied, but I know we have many vacancies on the bench. We actually have the vacancy on the Supreme Court right now, which has been in existence for a long period of time. We've been working without we're working with a 4-person court, and I think we need more people in the judicial branch. And you as a practicing attorney, I think it's tough to get a court date, and it's the dockets are just full.
I believe, Senator, I believe that's more due to COVID problems. I think there's a lot of attorneys who are champing at the bit to go up and move up as judges. My only fear, Lou, is that someone's going to be, if you have a 70, 75-year-old judge, now I know you are very capable and you're barely over that age. Do you think there'll be a problem with telling, do you think you've lost any steps over the years? I know you're a big football player. Do you think mentally, physically, you and I aren't what we used to be as athletes? Is anyone going to be able to come to a judge and say, you're not capable? If we see him slowing down, are they just going to cover them for them, Lou? If there's no need and we have younger attorneys who have been practicing for 30, 40 years who are ready to move in, do we really need, I don't, like Senator Guido was a pilot. At 60, they told him, it's time, because they know that you're a little slower than you used to be. Do you think that anyone's going to come to a judge at 70 and point out that he may not have quite the horsepower he used to have?
Well, that's a great question, and I think that's a difficult one to answer, because who's going to have the horsepower to do that? But I think we used to retire pilots at a certain age. We've extended that age. That age, that cap has been taken off, and they can work more time. So what we have done in the past decades is recognize the fact that older people have a much better grasp on things, and they're not limited as the thought process was in the past. The world has changed. We have different lifestyles, and I think that we're better equipped as we move along this path in life. But I mean, there's a time for everybody when it's over. But I think 70 is not a good age at this point in time. I think people 70 and over can really be productive in this society. And we have a president who's going to be inaugurated tomorrow, who's over 70. I think he's 77, isn't he? or something. I don't know the exact age, but I think we could gain a lot. We could gain a lot. And, I think we still have to be careful because there's a process for appointing people and there's judicial review. That you're a practicing attorney, you know the methods that are in place to examine people if they're not performing properly. But I just think that 70 number is inconsequential at this point in time. It
Thank
just
you,
doesn't make any sense. Thank you, Attorney Gannon, my seatmate.
Thank you, sir.
Okay, are there any further questions for Senator D'Alessandro? Okay, seeing none. Again, thank you, Senator, for your patience this afternoon. We really appreciate it.
Thank you, Senator.
Okay.
And stay well, everybody, and I can't say it, but have a great American Day. You all deserve it.
Thank you,
Thank
Senator. I don't have anyone else lined up to speak. Is there anyone else?
We do have someone with their hand raised.
Margaret, you're muted or somehow.
Oh, no, I can hear her.
Yeah, there was just a Timothy Horrigan with their hand raised.
Okay, let's put him through. Good afternoon, Representative. You got 3 minutes.
I'm Representative Timothy Horrigan from Stratford District 6, the towns of Durham and Madbury, and so I support the CACR. I think it probably should go even farther. I sponsored a very similar bill in 2011, which struck the entirety of Article 78, Part 2. That eliminated thus eliminating the age limit for sheriffs, which doesn't affect as much as Stratford County because we just elected a 35-year-old sheriff, so he could serve until 2045 before he hits the age limit. And he's an excellent sheriff. He just might do it. But as Senator D'Alessandro said, 70 is a much younger age than it was in the past. Also, when we put Article 78 in, wasn't me personally. I think it was even a little before Lou's time, where he was one of his first terms. There was no retirement system for judges, and also the judicial branch was less professionalized than it is today. So I think, like I said in my written testimony, I mean, it's probably not easy, but it is easier in the past to get non-performing judges of any age to retire than in the past. And if worst comes to worst, there is a mechanism called a house address or even an impeachment, although that's a pretty painful process. We had one of those a couple of those about 10 years ago, and it was very painful. And also, I believe we should also do it for sheriffs, because I think it's undemocratic to have a maximum age limit for any office. And so if the best candidate is over 70, I mean, if you do the job, he or she should be able to do the job. There is another similar bill coming through this year, and I'm on the House Judiciary Committee, which will hear it, which is sponsored by Bob Lynn, who's a former Supreme Court justice, and that's he's basically trying to raise the age limit to 75, and he has a procedure for assessing whether a judge is competent to serve after 70. So that hasn't even been heard by the Judiciary Committee yet, so it's not really the subject of it there, but there is a second bill that's similar. So I would certainly would support CACR 12 if it comes over in either as is or with the change I suggested, which is eliminating the age limit for sheriffs, which you can do, in which case you just be totally eliminating Article 78. And you might want to have some stats. So that's basically I'm glad to give it a try, and probably it'll have better luck with Senator D'Alessandro as a prime sponsor than it did, because that was Representative Joel Winters and we were both very young. We were both he was in our second term at the time, I was in my first, and so we were basically both rookie legislators. And yes, we fell 208 votes short of the number we needed to get it to the House. We got 32 votes, and hopefully it'll do a little better this time. And as I said, with Lou doing it, it's got a good shot. So
okay, Representative, that was terrific.
Thanks.
Just as you finished up, the alarm went off.
Perfect timing. Oh, good.
Yes, perfect timing. Are there any questions for the representative? Senator Gannon.
Thank you, Senator Carson. Representative Horgan, thanks for coming to our committee. Just a quick question. I've had parents who have aged, and as tried to take the car keys away, it was a problem. Once they got to the mid 70s towards 80, they kept thinking they could drive to Florida. Now, they couldn't drive to Florida, but they did. Do you see maybe the same type problem with a judge who hits a certain age? Taking the car keys away is not going to be a pleasant thought when there's so many tens of thousands of ready, willing, and capable younger attorneys with decades of experience. Isn't there a time and a place for all of us?
Well, yes, but that can happen before the age of 70. So we may, judicial branch may, and that may need some legislation, to ease out as dignified way as possible judges who just aren't doing their jobs. But there's, some people like younger than 70 who like aren't up to that job anymore. It's a tough job. I'm not sure whether the recruiting process is quite as easy as some people think, which I think actually we have a fairly hard time filling the number of judicial slots, even though we actually probably have too few judges for the amount of work that needs to be done by our courts. But so it's, from what I've seen, it's actually not that easy to fill a judicial appointment with somebody who is qualified and wants to do the job. So we probably shouldn't kick someone out just because they passed a arbitrary number on their timeline. So so that's a separate issue, like what to do about non-performing or poor performing judges. So that's as I said.
Thank you, Representative. Thank you.
Okay, are there any further questions for the representative? Okay, seeing none. Thank you very much, Representative.
Oh, thank you.
Is there anyone else?
Nobody else.
Okay, I am going to close the public hearing on CACR 12. I'd like to, before I take a motion to adjourn, I'd like to thank everyone. This was a very long afternoon. Anyone who has sat on Judiciary, Senator French as well as Senator Gannon, know that we do get issues like this where sometimes we're here to 7 o'clock. But the public has the right to be heard, and it is our job and our responsibility to listen. So I want to thank all of you for hanging in there, and I especially want to thank our staff, Ms. Martone, Ms. Waterhouse, and Ms. Horgan, for your work this afternoon. Thank you all very, very much. And so I will entertain a motion to adjourn.
So moved.
Okay, Senator French moves that we adjourn. Is there a second?
I'll second that.
Okay, Senator Whitley. Okay, I need to call the roll. Senator Gannon,
Yes.
Senator Khan,
Yes.
Senator Whitley,
Yes.
Senator French.
Yes.
You have that candy bar waiting for you, Senator French. And Senator Carson, yes. Again, thank you all very, very much for your work this afternoon, and we will be in touch.
Thank
Take
you.
care, everyone.
Thank you.